If your lordship's indulgence can mention a matter not on board, which was required to be listed today on the basis of a judicial order passed by your lordships earlier. It was directed to be listed today, it has not been listed, and I am suffering an adverse order which this court has been persuaded to pass on the basis of absolute misrepresentation of facts.
When that order was passed?
That order was passed on
Long back.
3rd of May. 3rd of May, my lord, that order was passed. And in the meantime, I was further granted leave to move the vacation court also. But I could not move the vacation court because of the non-availability of the advocate for the petitioner. So on the reopening day again also, we had made a mention.
Give the slip. Memo.
So new
Give all the
education
memos.
policy is being held at
Whatever.
council.
Give all the memos. List the Give all the memos. This person.
The specific fix on.
Yes, yes, please.
One matter, if I could appeal.
Lordship,
Yes, please.
First in common is a party, madam.
We'll release it. Let us appear. We'll release it.
Lordship, pardon to mention one matter, Lordship. Lordship, praying pardon.
That is the irony of the virtual mentioning.
They have the advantage to that.
Lordship, praying pardon.
Just wait, sir. There are other senior advocates who are mentioning. Just wait.
In fact, Mukherjee made a mention about that matter. Incidentally, I am the counsel appearing in that paper.
It will appear, sir. What is the difficulty?
I'm for the petitioner there. So, at least I request my lords not on 16 and these two dates.
Whatever, we'll see to it.
If you're
No difficulty. We'll see to it. Yes. Pass on all the memos. Yes.
Mantra Lordship's board number item 30. So remember that actuarial matter was virtually concluded. And I had just 2 more points to add some item 30.
Let it be a call. We'll see to it. Don't worry. Yes. What do you want to say?
Yes,
Somebody
Lordship.
doing a virtual mentioning.
Yes, Lordship, I am just praying for a listing of my IA in a bail matter.
Please pass on in the chat box. No
Yes,
difficulty.
one very urgency is that the
Yes, sir. No difficulty. You just pass on the memo. We'll list it.
I'm obliged. I'm so grateful.
Bail applications are not here.
No, Lordship, IA in bail, the bail order
Sir,
was
we can't
passed.
take it. Sir, this is not we don't have a roster with regard to that.
Lordship, the bail order
We'll
was
have to
passed.
mention.
My lords,
Where, Lordship? Where
can I be permitted to make a mention? My lords, a petition under Order 45 Rule 15, that is execution of the honorable orders of the Supreme Court, is pending since 1997. There is no special assignment.
Pass on the slip. Sir.
I have already given my.
Please, we'll see to it. Don't worry.
Yes, a special.
Please pass on the slips.
Item 35 not permitted to withdraw.
Yes, whatever. It's called the list.
For judgment item number 1, WF 441 of 2025.
If appeal is allowed, and as a consequence thereof, the restriction also stands allowed. But in circumstances without any effect, order has to pass. Have pending interlocutory applications are disposed of accordingly.
Item number 2.
Program credit for full chapter. Yes, my lord. This matter has been identified.
Yes, why? When you have filed, then do it. Why? He's raising an objection that you are frequently taking adjournment.
And this last, I'm taking last of the medical, I will answer whether amended rule is applicable retrospective or prospective. That point I will answer it after my huge time.
On the last occasion, due to non-availability of the senior counsel, you have asked for a time.
I prayed for last time. Only one point I will answer it.
Yes, on the prayer of the petitioner. 2 weeks. Yes, where is the affidavit of compliance? Where? When you have filed, sir, after 1906,
3rd July 2022.
where is that? Black?
Like C. Please.
Yes, this is relating to a water level.
Speak to Madam. Madam, you tell us.
Yes, now they say that all safety measures, all the things which are required to strengthen the stability of the dam has been ensured, and there is a extensive, I think the extensive exercise has been done to just find out whether the dam can sustain this amount of water. It is said that there is no difficulty. And you can't play with the lives of the many others in the garb of this. They say that if I discharge some excess waters, then it will have a cascading effect, because it will invite the flood to come. Many inhabitants of the nearby villages, they would be affected by this. By one initiative, can you do that? Can you play with the life of the others? So
My humble submission is
you have come, I understand, if there is any wreckage or if the dam breaks, that it will cause a lot of casualties. But now they have said stability.
but we have no doubt about the strength and the
What you will do if there is a dam, there is a huge accumulation of the water, then either the water has to be discharged. If the water is discharged, it will invite a flood. So they have said that we have made a construction so that the dam can sustain this amount of water. And you want this level has to be maintained. It cannot go beyond that. What they will do, they have to discharge the water. Can we pass an order for removal of the dam? So
we have not. You will also be actually they are public question about the story.
you are a public spirited person, but you should be very reasonable.
I humble submission, Your Lordship. This is a question about the offering. The rise of height of the dam was taken in the 19.
Sir, you have said when this was constructed, there was.
Illegal by the Honorable Supreme Court, Your Lordship, and departmental proceeding was
I understand.
against the officials.
Correct.
Those are involved, the irrigation officials are involved in the rising of the dam height without permission of the state government also.
Now they have said that every permission has been taken.
We will also, this is in the order of kindly glance to the page 22 of the order of Honorable Supreme Court.
Where is the order of the apex court?
Page number 22, Your Lordship.
Page 22 of
Annexure 4, Your Lordship.
Annexure 4. Let us see.
Second para was.
So it does not really rule out. The Supreme Court has not said that. Only thing is that the permission of the central government is to be done. The permission of the forest, because if they have deforestation has been done for this purpose, they have to obtain. Now they have approached. Where is that affidavit? They have disclosed in the affidavit. They have disclosed. Supreme Court has not ruled out.
The permission is still not granted.
Yes. The proposal for the diversion of the forest land measuring was initiated by the government of Odisha now, which was rejected by the government of Ministry of Environmental. The National Board of Wildlife also rejected the proposal. The then executive engineers filed a IA before the court with a prayer to modify the order passed in therein and to direct the MOI such and such to give. The Forest Department government has paid an amount of rupees. The Supreme Court said that you have not paid the compensation. Now they have said that this much of an amount for compensatory afforestation of the non-forest land of 575 hectare in lieu of the submerged land in the year 1993. Now requested the ministry to consider the diversion proposal. The state government has been regularly following up.
It is still pending, Lordship. The proposal is not approved by the.
So why who is representing them?
Explain this whether proposal is approved or
Ministry of I think the environment or the forest.
of India.
What are you doing? Take a decision. What instruction? Take a decision. Because the difficulty is that during the rainy season, when the amount of water becomes high, then what to do? They have no control over the natural phenomenon. So the apex court was more concerned that you have utilized the forest land, you have done a afforestation, and everything has been done without paying any compensation to the forest department. Now they say that they have already paid, and they have now approached. So take a decision. You're representing which opposite party? Pursuant to the order dated 19/6/2025, the affidavit is filed Yes, serious allegations. Embezzlement of the public fund. What you have done?
Lordship, inquiry has been done, and the delinquent officer has also been transferred from there's a posting. And
Transferred.
yes, inquiry has also been done, and a show cause notice has also been served. But relation to some use of a car and registration, the other inquiries is clear, Lordship.
You have conducted inquiry.
Yes, sir.
You have conducted.
No,
Or not?
We are-
You are vigilance. You are vigilance.
We have not inquired. There are mainly three allegations. One is employment of vehicles and purchase of 3 numbers of non-branded almiras instead of branded almiras, and engagement of outsider and outsider women in the department. And so far as the allegation is concerned,
Outsider women in the department means?
Outside the Lordship.
They are not employees. She has taken help of others.
So destitute women.
Destitute women. That is the allegation. And we contacted the ADM Koraput, and Koraput clarified that initially there was a complaint by the chairperson of the Child Welfare Committee, and that was inquired into by the assistant collector, and he has made submitted a report in the year 2021, and thereafter the collector again inquired, ADM Koraput again inquired into the matter and found there is some irregularities and suggested for departmental action, and no departmental action has been taken. And in the meantime, that person has already been
He is retired,
transferred.
transferred.
And so far as other allegations, they have not made any material to substantiate the allegation.
What?
So far as the disproportionate asset, anything.
You did not find any irregularities. That inquiry was done. Preliminary inquiry. You have collated all the records. Yes.
Reply.
You file your affidavit and let them meet. Because it is the nature of a public interest litigation. It's not an adversarial litigation. So you just disclose all the facts. And let us see. One person cannot come and say that I have got all evidence. If he has an evidence, let him give it to you.
The almiras were purchased, Your Lordship. Those almiras were found in the office, but they were not in accordance to what the collector has said, the brand and the involved.
Why there will be a promotion of a particular brand? I'm just asking out of the way. Why there will, if it is a competitive price, if the quality is not compromised, then why there will be a particular choice of a brand? Why there will be a choice of a brand?
The counter so filed by my
It's not a counter, it should be a supporting affidavit.
Supporting my allegation and my contention, and it has been well proved.
What well proved? The only thing is that, please, Almira has been bought, the Almiras are bought, not of that particular brand. Why you are so interested in a particular brand?
I will not refer in the brand, man.
So,
What is the finding in my annexure, man? It is stated that there were some irregularity, financial irregularity.
sir, you have said financial irregularity. You have not pinpointed the financial
I have
irregularity.
pinpointed.
If you have, they have found nothing. They say that during the inquiry, preliminary investigation inquiry, we do not find any semblance except some allegations of employment out of
They have
the way.
They are accepting my contention. In the counter also they have accepted
What?
that they have, the irregularity so claimed by me has been well founded, man.
What is well founded? They said that yes, it was not purchased that particular brand.
No.
But they have purchased the Almira. Almira is already lying in the office.
Your Lordship, may kindly come to page 22 of my petition. They are accepting mine. The sub-collector himself is accepting there is some financial irregularity, and it has been numerically stated here.
That explains.
At page 22, ma'am.
recovery should be done from 2019 onwards, Your Lordship.
But in the year 2022, my lord,
This recovery, this was a misuse or abuse of the vehicle.
Vehicle.
That's the only thing that you have already, that you have said that you are going to recover it.
but they are accepting, man. They are accepting.
So what do you want?
But an inquiry has to be there, man.
What inquiry they have done? And they found, yes, there was some irregularities in use of the vehicle,
Man.
and the amount which the government has suffered, we are going to realize from him. What more you want?
In the year 2022,
Whatever they have to take a decision. They have to take a decision
As for
whether they will impose the interest or they will not impose the interest. It is up to them. Who are?
let them file
Let them.
counter.
They what they
Let them file
counter
counter.
unnecessarily the counter.
Let file a counter then.
These are possible.
And as far as the employment of the destitute woman is concerned, she was employed with the fabrication unit where 1,500 rupees was paid to her as an advance. She left after the next day, so she was apprehended and 1,000 rupees was returned to the fabrication unit person. And this matter was also reported in the police station in Assisi. So there's no, all these steps have been taken. It's a departmental inquiry, and also Shoka's notice has already served on and she has also been transferred from this place.
This is totally official misconduct and minor violation of departmental proceedings as far as the allegations are concerned.
So departmental proceedings is continuing.
No, my lord. No, my
Yes.
lord. Sorry, I beg.
Stated.
No, we have only got the information Shoka's has been given.
No, you have stated in your affidavit that the Chopra has been.
File any affidavit because on the last
So
occasion.
you just file your affidavit, disclose that you have already initiated a disciplinary proceeding. He cannot control the disciplinary proceeding, that we know.
Oh, bless you.
We will restrict his interference to that. You can't control that what the investigating officer or what he will do, he cannot control that. Being an outsider.
Bless you. 2 weeks.
It is.
Item number 6.
But here the petitioner is a license of hostel liquor shop and he has 4 branch shops. But out of 4, he has applied for surrender of 3 branch shops in the month of 13th February 2025 under Annexure 6. No, it's not passing in.
You protect the liquor shop owners. Yes.
Under Annexure 6 at page 50, that is the application they have not considered as yet.
That is subject to deposit of unutilized fee, my lord. Now the outstanding
Utilization of NGQ.
yes, my lord. There is Mohawk floor, he has to procure.
He is the manufacturer.
Yes, yes, no.
Annexure 7 may be seen as page 51, my lord. We have communicated the dues
Yes.
unutilized fee. Your lordship may dispose of representation subject to compliance of the requirement of section 49 for giving
Section 49 says about surrender of license, where it says that he is to give 1 month notice. First, second is he is to pay the license fee consideration money. I have cleared all consideration money and license fee. But with regard to this non-utilization fee, I have no instruction because I have filed on 13/3. Now it has come. So with regard to, I think it must be paid. Because otherwise, his license will not be renewed. His license has been renewed, 25-26.
section 49.
But with regard to this surrender of 3, they are not doing.
Sorry.
They are sitting over the mat. 3 license, branch source of licenses.
Surrender to be considered subject to payment of this. That is a clear provision.
But I have also
When
enclosed.
the renewal has come, when a renewal has come, then in addition, you may not have renewed the license unless all the dues are cleared. That is what he anticipates.
Yes.
No, your law is very clear. He
So,
said
surrender
that we have
is-
renewed the license for 25-26.
Yes, my lord.
And these are the demands prior to that. This is 24-25.
Miller.
So he says that if you have renewed the license, that means that this amount must have been paid. Otherwise, you will not renew the license for 25-26.
But the demand has been right on Annexure 7 for unutilized
Oh, that is what he says.
Yes, my lord.
That is
Sir,
24,
Please
25.
consider,
Yes,
he
yes.
says that though he has no positive in structure,
Yes.
but he says that if the license is renewed for a subsequent financial year, 25-26, which is still continuing,
I have also to take instruction.
then it implies that without the payment you will not renew. It implies that he has made up. What he says.
I have to take instruction on that.
Please.
I have also relied upon the order of the Honorable Court, wherein similar matter was also disposed of. The Annexure 8.
What? To consider the
Yes.
representation.
But they have done it. In that matter, they have done it. The collector has been directed and he has done it on the basis of the Honorable Court's order. That's why I have used. There also I appeared. So,
This why he says implied. That's why I use the word implied.
But after representation made, thereafter this demand has been made to him.
No.
So it implies says that he is not
Subsequent event
prohibited.
that you have renewed the license for 25-26. That is what he's saying.
for surrender, it is not precondition. Surrender precondition is license fee.
Yes, next.
Item 7.
May I please look? Okay, the opposite party number 4 is allotted a lease, mainly lordship
Lease for
lease for operation, my lord, that is my lord Bhargavi River sand Sharath lease for operation of yes, sand. Your lordship, by virtue of the advertisement under Annexure 1, the period of lease is my lord 2020-21 to 2024-25. 2021 to 2024-25. 5 years.
25 means it runs from a 1st January to a 31st December.
March
or financial
20,
year?
March 20, finance.
March.
But your lordship may kindly see
So
that
according to you, it has expired.
it has expired
Then
and he has not operated the lease. He has not operated the lease, he has not paid the money to the
he's
government.
not operating that quarry.
After expiry of that period, my lord, he is allowed to operate. And as per the law, if he will not operate for 3 years, it will be cancelled.
Automatic.
Or to your lordship may kindly see 26 rule 26(9). I may be permitted to that.
So essentially, it's a question of fact, whether he operated or he did not operate. This is
Well, no, it is revealed from the district survey report, your lordship. It is.
You show me that
That were page 38, your lordship, mechanics.
minor mineral concession rules.
Yes, minor mineral concession rules 2016,
Which
Can it be
rule?
permitted?
26(9).
Can it be permitted? He has to make the mining officer a party, your lordship. And the state
Permission
of
is
mind
given
is
by
party.
the Tahsildar.
No,
Minor.
Tahsildar can't be. Now the amendment has come, sir.
Then I
Now the
will,
power of the Tahsildar has been
then
taken
your
away.
lordship may
The mining officer who is placed.
your lordship may be kind enough to grant me.
If preliminary objection is raised by the council for the state that
or 8.
The hands of preliminary objection.
In this case, the contractor executed a contract on 18/1/2018. 18/1/2018. And
what is the nature of the contract?
nature of the contract for construction
of the brief construction.
that the GST Act came into force with effect 1/7/2017.
So
That-
you were given a contract prior to coming in force of the GST.
After.
So after or prior?
After.
Okay.
Once GST Act came into force on 1/7/2017, and my contract was executed on 18/1/2018. About 6 months after.
Yeah.
Then, my lord, kindly turn to page 5 to page 29, annexure 5. Page 29, annexure 5.
Annexure 5 is not a piece 29.
Please, running page.
You are referring on letter dated 10/2/2025.
27/10/2022.
27.
This is 27/10/2022. That's what 5.
Here is the maximum. No, there's no letter.
Annexure 10, page 29.
Page 29.
You are carrying wrong thing.
My REIT application, annexure 5.
14348.
27/10/2022.
You are appearing in repetition 14348.
No, my lord. 7776.
So, we are not able to get it. Where is that file?
You are carrying wrong.
You are carrying a wrong file, sir. Item number 8 is WP 14348.
Sorry, my lord. Another file.
Yes.
Who is appearing? Huh? Oh, you are appearing, sir. Your name is appearing.
Yes, ma'am. That is another. Sorry, my lord. Let it come next week. Another file. Same petitioner, but that is another.
This matter.
Sorry.
And this had appeared.
Sorry, ma'am. Let it go next week. Monday or Tuesday.
Yes. Yes.
Maybe next week.
Right. Item number 9.
Item number 8. Next week.
Next.
I will take instruction. Take instruction. We are the next week.
Item 9.
Item number 9, I'm for the opposite parties, for union of India, the copy of the solvents.
Lordships, in email it is served. It's served today. The copy is served by email.
लेते हैं हार्ड कॉपी में सर्व देन नेक्स्ट डे टू HST को that by land brand
Lordship, we have the hard copy. We'll serve it to you.
We serve it next week.
Well.
online
Number 10.
The very serious allegations he has out there. Kind of corruption allegations, we do not let things go so lightly.
Get sought for instructions.
No, this is not expected from the authorities. When such a serious allegations are there, and you've seen the very recent judgment of the apex court in this. The Supreme Court, even in case of a bail, has said that there should be very strict parameters that should set. We'll not let it go in this.
Let's time lodgement and file it. Let's check it. 2 weeks.
Yes,
2 weeks time lodgement and file it.
they have to find it after.
Let's I'm praying for stay. Let's
Stay or
stay of supply.
PIL stay. I never heard.
Let's
What is
Let's-
stay?
stay of supply of the bars here. Let's see if the supplying process is going on.
Whereas whatever is there, they are supplying. If that is the
Okay.
thing, the corruptions and all, everything has to be done. You can't
Okay.
keep anything at fault.
Okay.
And ultimately, if it appears that there is no corrupt practice, then who will suffer? So stay definitely not, madam. Was the Eastern Public Interest Litigation is.
Twenty-eight. Item 11.
Okay.
The tender is related to construction. Boys Hotel. Boys Hotel. I never heard of Boys Hotel. Hostel. Please come to your prayer aid. For the work construction of 100 seated boys hotels. I was really surprised with that. That hotel.
Your Lordship, can you come to page 25? There is construction of proposed 100-seated boys hostel, G+2, at Government ITI, Namdapur, in the district of Korapur, for the year 2023-24. And the approved estimated cost was 726.75 lakh. With 7 crore 26 lakh. Around. The present petition is the successful bidder things. And for a very minimal reason clause, this tender has been cancelled by Annexure 1. That is because bank guarantee could not be furnished. It is delayed only by 10 to 20 days. But plus, I have already given the bank guarantee.
Too small time.
Yes, sir.
25 days is very small time.
Because to get the bank guarantee from bank, it takes time. We have to deposit stamp papers, everything, and we have to depend upon the bank.
Is there any time limit given for promising the bank guarantee?
I humbly pray your Lordship to come
Where
to
is that?
Annexure 6.
Clause? Where is that clause?
Your Lordship can come to Annexure 6, page 76.
What is the timeline within which you have to give a bank guarantee, sir?
That is, they have written 7 days because that is a clause is.
I just wanted to look at NIT clause.
Yes, it is page 42 clause.
Page 42, Miller.
42, 1.5.
1.5.
Top clause. At the top.
The successful tenderer shall, within a period of 10 days from the date of written intimation of the acceptance of the tender, deposit with the concerned authority a sum of such amount towards initial security as put together with the earnest money, make 2% of the work as per the accepted tender, excluding the additional fee.
But I pray your Lordship to come to page 70.
I am talking about the bank guarantee. He's talking about the bank guarantee. Where is the?
Your Lordship will come to page 76. You also get it. The letter from Dick.
It says it's a deposit with the concerned authority, some equivalent towards the initial security. So it's a deposit. Where is the guarantee clause?
Annexure 6, you also can see that is from the government of Orissa.
No, under the NIT, is there any stipulation of bank guarantee?
That is the acceptance letter, but that is reflected there.
APS is to be deposited, Miller. APS is to be deposited. That's it.
So now you say that instead of the deposit of the money, you can give a bank guarantee.
Lordship, kind page 42, clause 1.6.
1.6.
Yes.
Additional performance security will be deposited as per the office memorandum dated 21.
And that office memorandum, they have annexed to the writ petition at page 111, annexure 17 million. Towards 111. Annexure 17. Towards the middle million. Within 7 days of issue of letter of acceptance. Now let's see, kindly turn to Annexure 6.
The counter guarantee by its local branch of the Bhubaneswar within 7 days from the date of the letter of acceptance. So that now you are aware, NIT contains this.
Yes, sir.
Instead of 7 days, how much time you consume?
This is maximum 20 days. Plus, I'm coming to Annexure 6. Yes, let me next one. Annexure 6 is the acceptance letter. Sir, your tender for the above work has been accepted for an amount of.
So this is 21st of February.
Yes, 21st of February 2025. Of 6,52,62,000, only being 10.20% less than the estimated cost put to tender. Hence, you are requested to attend this office within 7 days from issue of letter of this acceptance of drawal of agreement along with the following documents without fail, otherwise your tender will be rejected. Plus, these are the documents required. Plus, next last part, if fail to deposit the above documents in time, the tender may be liable for rejection with penalty. Plus, next page. On 11/3/2025, I have made a prayer. That with reference to above referred letter, we beg to submit herewith that we have applied to the bank for issue of bank guarantee as per the above letter, which has already been approved, and it will be issued after receipt of your bank IFS code. Hence, you are requested to provide us your bank IFS code and allow 2 to 3 days more time to submit the IST and FPST in the form of bank guarantee for execution of agreement for the above subject to work. Plus, next was that the bank guarantee that is on 13th March.
When this letter of 21st February received by you,
Yes.
on the same day,
Yes, boss. Because
yes, I got the next page also, page 17.
Yes.
Now the bank guarantee is issued by the court of final.
that is on 13th March 2025.
This letter was 11th of March.
Yes. Yes.
So, So now surely is there any provision for the authority to extend the time?
That is because that is you'll also get it at page 88. From there plus letters you also can get it. The way I have been removed away from this tender.
Wanted to know that the authority has been conferred with the power to extend the time beyond 7 days. This is what I just wanted to know. Anywhere there is power is reserved. Any line.
That is, they have stated in this with reference to above note, I am reading page 88, annex 9. That is 18/3/2025. With reference to above notice, subject to say that you have been issued LOA for the above mentioned work for drawal of agreement, but you failed to do so in time allotted to you. Then last part.
This is the letter of
18 March 2025.
17. Signature at the bottom.
Signature 17th, yes. But letter dated 18/3/2025. Superintendent Engineer Rural Works Division, Sunavada. Someone has written 17/3 and other signature is 18/3. Then I have given a response that is at Annex 10, page 89. The relevant para is last para at the bottom. Finally, after a gap of nearly 1 month after date 21/2/2025, the letter of acceptance, an unknown person other than the person as mentioned in license, my authorized representative was visited this office on dated 23rd March 2025. On that time, the bank guarantee has been deposited to submit bank guarantee towards FPST and IST of the above work. The person didn't present in documents towards his identification and his relationship with the original agency, Mr. DK Engineering and Construction Special Class Contractor. There was no reply submitted explaining the cause of delay in response to show cause issued by the undersigned. Plus, my objection is not a flimsy round. Plus, page 90 again, I'm showing.
Yes.
In the meantime, L2 bidder of the above work, Sri Rajesh Kumar Padi, because I made him opposite party, A-class contractor has submitted his grievance to the undersigned on 10th March 2025. Sri Padi has claimed that he should be awarded the work as the L1 bidder has not drawn agreement within the stipulated time allotted. The grievance letter is also enclosed for your kind reference. As of till now, there has been no further official correspondence between the office of the undersigned and the agency, Mr. DK Engineering and Construction, Special Class Contractor. Thus, it is unfortunately understood that the agency is not interested to execute the work. Plus, I have deposited the bank guarantee, I have drawn the bank guarantee, I have deposited before the government and the government authorities. Plus, they are saying here that I am not interested to execute the work. Then, plus, next letter is also important. I have written at page 91. Dear sir, with reference to above, we beg to submit to that. We had requested by our above report letter to give some extra time to submit IST and FPST.
This was the festive season after 13th of March.
Yes.
What festival?
I have.
Yeah. What is the festivals? They're very important. In the month of March. Except the holy.
Holy, that is holy. Due to holy. And that also I have written it on my letter dated 27th March 2025. On 30/3 2025, bag guarantee was issued to us, but could not be submitted to the office due to festive season. On 20th March 2025, our representative Nitesh Kumar Jain had attended the office of the superintendent engineer and submitted the bank guarantee towards IST and FST. Copies of bank guarantees are enclosed herewith for your reference, please. Now writing to the contract that contractor is not interested to execute the work plus clause 5 is very much surprising on our part. Moreover, intention of the department is not understood at all. Now we request your good sir to kindly allow us to execute the agreement.
What happened?
I don't know.
Then what happened?
Then loss what has happened? Then annexure 1 lost with. Certainly, because I have received the letter. We get it at page 21, annexure 1. With reference to the subject cited above, it is to intimate you that a tender committee meeting was held on 14/5/2025 under the chairmanship of Chief Construction Engineer Rural Works Circle, Sunamana, for finalization of the above tender. As per the decision of the committee members, the approved tender for the above work has been cancelled because you were failed to attend for drawal of agreement within the prescribed time period, neither in person nor through your authorized representative. Now, they have received my bank guarantee. I have given all the documents, plus not signed the agreement with me. The Atlas was on 15th May 2025. They have cancelled the they are going to, I mean, they have said that we have cancelled the tender. Of course, it has not been given to the L2.
Well, again, I repeat the question, where is the power given to the authority to extend the time for deposit of the bank guarantee?
That is of course a draconian clause, so I have to verify it.
If that particular, the office memorandums are there previously, all the contractors are aware that these are the conditions. You could have immediately asked for an extension of time, or at least when you received a letter of 21st of February, you would not have waited till 11th of March. You could have immediately written a letter on 22nd or 23rd of February that you are giving me a 7 days time. These are the requirements of the bank. Please furnish me those. Please extend the time for execution of the agreement. You have not. You sat over it. Till 11th.
No, not
only first correspondence was
of
11th of March.
Plus 11th of March, I
when 7 days expired.
Yes, you are correct.
So what to do?
Kindly have a glance to page 98 minutes. That is the portal provision of OPWD code they have annexed. 98 minutes. Serial number 2. 98 page.
They are all draconian clauses they have introduced, because now L2 bidder for only 5 days delay.
L1 bidder.
Not 5 days delay, sir. What are you talking about? Your bank guarantees of 13th March.
Yes.
21st March.
Yes.
And 21st April. How many? 10 days there.
Plus
13 days here. That means near about 22 days. 22 days. And you did not deposit on 13th also. You say you took a plea of festive. I was just looking at it. 14 was the holiday, must be for Dole. And at least it reopened on 17th. You went on 20th.
Because of the festive season, he could not go on 20th. He has gone and
festive season is not the festival.
Okay.
That was on 14. It ended on 14. You could have gone there from 17, 18, 19. You went on 20th. Your representative.
Was 20th and they have received my document. They have received the bank guarantee.
Whatever. But the office is not supposed to go into all these aspects. They received it.
Plus, these aspects also have been dealt with by the Honorable Apex Court in other cases.
Yes.
Plus,
yes. If you have a law in your favor, no doubt.
Yes. Plus, they are in a similar situation. What has been done? some fine has been imposed on the contractor because of delay, but it's a minimal delay. There was there is much more delay was there. Then I offer to lordships judicial consents and lordship discussion because it is only for 10 to 15 days because I have been the lowest bidder.
Yes, show me.
Will are delayed due to unavoidable circumstances. The agreement also providing for penalty. Lastly, I am coming to
Just 1 minute, sir. I'm a very fast reader than anybody. Just give me 2 minutes time.
grateful to lordship.
Yes.
Yes. Para 14. Yes. Then was I'm grateful was gone through his past was. Para 14, while setting aside the termination of the contract.
Have you read?
Yes.
Judgment. If judgment is
basically upon
or or a decision is what if it's decided in the perspective of the facts? Have you gone?
Yes,
through the facts?
yes, yes.
Do you think that this will apply? Because there are two distinguishing features here. One was for commissioning that particular plant, 210 days was allotted, though the order was issued, and it was a bidder who has to find out the land. He could find out the land, but the land which was allotted by the government, it was enclosed by many squatters. And it appears on the measurement that the land fell short of the requisite plot. They immediately applied the authorities so that they can change the location because he wanted to change it. The authorities extended the time to change, and this consumed, then the government was approached, then the government allotted the land, this consumed 83 days. Because 210 days was the deadline within which the entire project is to be completed. So this 83 days was consumed, which was beyond the control of the bidder. And it is the authority is also unavoidable. The moment he wrote a letter that now it is absolutely at the final stage, we want to commission it on 31st of August. On 11th of August, immediately letter of termination was issued. When everything is at the final stage. So 83 was considered to be a time which was consumed to be given to a bidder to complete the project within 210. Then the court noticed 2.5.1 clause 2.5.1 there, which says that if you do not commission the work within a time frame for 1 month, first month, 1%, like this, the penalty will be imposed. So the court interpreted when you have imposed a clause included a clause for imposition of the penalty, then in that event, you can impose a penalty. You should not take a harsh decision of the termination. You cannot go both terminate and then impose penalty. When the penalty clause is already there, then you enforce penalty clause. Is it a case here?
No, sir.
I'm ready to accept it. Had it been a case that if you do not deposit, you will be charged with this penalty, then the question of extension would automatically come. But here is not. So how this judgment?
No, that is because paragraph 14
paragraph 14 has to be read in
yes,
the factual scenario of fact. Directed you of fact. This is the fact.
Factual scenario of the matter. Plus, let me go through the conditions contract.
That was only absolutely. It was very clear that the stipulation was a penalty. Once the penalty clause is there, then you cannot improve that.
Plus, I humbly pray for 1 day time. Plus, tomorrow I'll go to the agreement clause. When the clause is helpful to me, I'll just go to the clause. I humbly pray for plus, maybe call tomorrow.
Unless you don't specific terms, the author has the discretion to
extend
it.
That is what the first question is.
Yes.
If they have the authority to extend the time, definitely we are with you.
Yes. I'll finish.
But there is some lapses on your part. You could have responded there. He responded spontaneously. You could have responded immediately within 7 days from the date of 21st of February. This is the position I have already applied for, and they require these information. Please furnish me an information and extend the time for You did not till 11th March. What more?
There is no clause to explain me. Rather, OPWD court mandate.
Since the person is not agreeing, he is buying time. Are you not understanding? So let him satisfy his conscience. Tomorrow,
very good.
Very difficult.
Let me see.
Your conduct is. Had it been within 7 days, it is what are you doing?
There was also another PIL, Basanti DG versus
6497 of 2024 is also
attacked with it.
Yes, Your Lordship. There also, Your Lordship, the authorities have given affidavits, Your Lordship. I would also.
That is that matter. And both the matter when that matter is directly to the minister.
The Lordship, it was there on the last occasion on 2/4/2025. After that, it has not been listed here.
After 2 weeks, let it list along with.
Next week, very important.
2 weeks, sir.
The specific date.
No, we are giving you. It's not wrong.
Item 13.
Both the one.
Mike.
Yes, Yes, sir.
If the petitioners have filed this writ application by way of interest of public interest litigation, they were not considering genuine grievance of the opposite local resident of the Kesinga town lordship.
Wow.
Lordship, the genuine grievance is construct a bypass road.
That was as per the original plan.
Lordship.
From plan
Initially, Lordship.
Yes.
Initially,
the decision that has been taken.
National Highway Authority.
No. Whether there has been any policy decision taken to construct, because he says as per the original plan you are supposed.
Lordship.
So whether any decision has been taken at the military level so that the NH will take the responsibility. Anything has been done.
Okay, construction.
Disclosed.
Okay. I put it in something.
To take instructions to make.
One copy will be sought to the NSA.
And what is on the NH?
Item 14.
In the order of 74. Next one.
Page 19 annexure 1. This is shifting application rejected. That should be received from the first layer.
What is this rule 26?
26 is the prohibitory not within which what distances shop cannot be allowed.
Yes.
The distance factor, prohibitory distances within which a shop will not be allowed, that is subject to government's power of relaxation is there. Rule 26 will not detain my lords because the first line itself, your lordship will look at.
Let's start with the negative sentence.
Right, but rule
Can be granted.
Rule 26
That
will not
the
detain.
proviso says that so far as the minimum
That's it.
the guaranteed distance is concerned, that can be relaxed.
But that
in the special
rule 26, I think, will not detain my lords for considering this matter. The lordship will look at the very first line because the procedure is collector submits a report to the commissioner. Commissioner submits recommendation to the government. Now, government considers the recommendation and passes out. That's the law. Now, government, while rejecting this application, has considered the recommendation of some other shop. Kindly see that. That total non-application of mine.
You're there?
I am directed to invite a reference to letter number 4682 dated 31/3/23. Got it, man? Kindly see page 72. 72. I'm sorry. That is 67. I'm so sorry. Page 67. Page 67 is not a recommendation in respect of our shop. Something somewhere Malabar IFL restaurant also. Thermosai in the district of Jaspur. Mine is in the district of Cuttack.
Submitted proposed shifting of the Malabar.
Yes, in the district of Jaspur.
Yes.
Completely different recommendation has been considered. My application is rejected.
Yes, sir. Yes, madam.
I take instructions to Lordship.
So I thought, the letter number date is
The
there.
Malabar, it is for Malabar.
Your Lordship.
That is the Jala Sukha.
Yes. Jala Sukha GP, PS Dharmasala, district Jaspur. This is that recommendation. But this has been considered for my shop and rejected.
It can't be said that it is cut paste syndrome because everywhere the same thing is repeated, even in body.
Yes, Your Lordship.
Definitely it is a non-application of mine,
Yes.
the non-application of mine.
Right. And on this ground, this should be set aside, remitted back for press consideration. So the commissioner in our case has recommended relaxation.
What is your
Beg pardon.
name of your
Milan restaurant, Milan restaurant on South Cuttack district. That appearing in the subject of this impugned order.
The instructions, Your Lordship.
What instruction? Look at the letter.
What's the article mentioned?
This is the reference which you have given it a copy of. You wanted, you wanted the shifting of your shop.
Right.
On shop or off shop?
On shop.
The the letter
Definition is the this.
Item 15.
Okay, my lord, mirror order that will be passed, my lord, that 180 ml.
What? Oh. Go ahead.
Item 16.
Your last the public interest litigation filed by the villagers and the interim managing trustee of the DT minor. The fact of the case is like this one. The
EIL lines.
EIL line.
You are a directly affected person.
We are the villagers. We are not affecting the.
You are the you say that is the committee of
one of the petitioner is the interim trustee, interim
so
managing trustee,
because he is owning the property of the DT in trust. Then he is the directly interested person. If the land of the DT is sold by executing a sale deed, then he has to take recourse to a proper.
If your lordship turn to Annexure 8 onwards till Annexure 10, my lord, the managing trustee along with the villagers several times wrote to the environment commissioner, district head, and all the authorities, my lord, about this mismanagement of the selling of the property of the DT. Exactly.
Please kindly consider. Now it raises a very serious question.
Yes,
the first issue to be whether the property which is a subject matter of a sale deed is the property of a DT. First, you'll have to prove your title to the property. The moment you prove that this particular property belongs to the DT, then the sale have to be declared null and void. How it can be declared null and void? By instituting a proper proceeding. Yes. How PIL lines are just
the authority who has to safeguard the interest of the DT, my lord, the authority endowment commissioner, my lord, who has to safeguard the interest of the DT and its property, my lord, they are in connivance with the revenue authorities selling the properties, my lord.
You are an interim trustee.
Yes,
can you not bring a case as a trustee?
Yes, my lord. If you
challenging the sale deed.
Challenging the sale deed, my lord. Lots of sale deeds are there, my lord. Lot of sale deeds are there. From 1970, and there is a restraint order from the environment commissioner to all the concerned not to register any sale deed. I have, if your lordship turn to one annexure, my lord.
Even if anything is done on the teeth of an order,
yes, my lord,
of injunction or law, then you'll have to seek a declaration in that regard. The first issue you have to prove is that this land belongs to a DT. There must be some document.
Yes, I have filed the document.
There must be a deed. There must be a deed. There must be a settlement. There must be everything.
I have filed the ROR, my lord.
ROR is a decisive document of title. I am asking you. Tell me, is it a decisive document of title? Entry in the record of right, whether it will create a title or extinguish a title. I'm just asking. I'm conscious of 1996 Volume 6 SCC, 1997 Volume 7 SCC. In both the cases, the Supreme Court in unequivocal terms says that the entry in the record of right is not a document of title, nor it can take away the title of any person. It is only for the purpose of making a person responsible for payment of a land revenue. Nothing more than that. How can a title be created on the basis of ROI? You have chosen a bad civil lawyer.
No, not at all. Not at all. My fact is this, my lord. But you will also come to for a moment, my lord.
Sir, I am asking you a question, sir. I will go everywhere, but you answer this primary question. You are relying on an ROR. I am asking you whether it is a document of time. I am just asking you. If you prove then I will enter that if you are a title holder, whether by this means government can sell the property. I am conscious of Article 300 capital A of the Constitution. I am conscious. But you'll have to prove first. Then PIL. Then the question would come as PIL.
I have filed the RO and filed annex of 4 miles. Who shows that the property.
No, that we have a presumptive value of a position only.
Yes, ma'am.
Nothing more than that. That is a rebuttable one.
On the basis of that, I wrote to the Endowment Commissioner to safeguard the.
You can't. You first prove your title first. Otherwise, we will not, the busybody, the interloper, they will not be permitted to misuse the power of PIL. No, sir. You'll have to go some other way, or some other place. Again, the question of limitation would come if the deeds have been executed in 1970.
Now they are
going you are coming.
It's not, I am saying that from 1970 ROR is there. Now till today also they are going on.
So they have started from 1970.
Yes, ma'am.
So can you challenge the deed which was executed in 1970? Taking on the course of a PIL.
1970 property comes to the DT. Thereafter, till 1993, it was intact matter. After that, they are going on selling matter.
Can you sell the 1993 deed, 94 deed, 95 deed, 2000 deed, 2005 deed, even 2021 deed? What is the limitation period?
12 years.
Oh, very important.
3 years, right? 3 years.
From this execution of it is 3 years.
3 years.
Adverse position.
Adverse position. How adverse position? 3 years.
I'm permitted to withdraw and file the.
No, sir, it does not come. No PIL. It does not have a public element.
For a movement, you'll also may turn to Annexure 7.
Then we have whether these kind of peoples can come forward and raise these issues as in the PI. Then I do not know, some observations may affect.
That amendment, I may be permitted to.
Yeah. Now you mind what you can do. You have a remedy, but not this. Yes.
Well, item 17.
Your Lordship, this is also a PI. Now, what I seek to raise is what I refer to as a royalty scam with respect to non-payment of royalties in respect of minor minerals. I have been filing RTIs right from 2023. I asked for my first RTI, and the cracks have appeared through documents I've got through the RTI. So my first RTI, the very first annexure, my lord, at page 29. Given that this particular private entity, OP number 2, well known in Orissa, was conducting large-scale construction activity in a particular area, I asked for how much construction has been done by that particular company, what is the amount of royalty that has been deposited and paid against the minor minerals used in that work in the last 5 years. I filed RTI after RTI. The first crack appears last year on the 20th of June 2024. My lords may have page 55. Now this comes from the office of the Tehsildar. It says at the bottom of the page, so-and-so and so-and-so has not deposited any royalty during the past 5 years.
Where? Page 55.
Page 55 at the bottom. Annexure 4 at the bottom after the public information officer's signature. This information is not available in the office. Then so and so and so and so has not deposited towards royalty during the past 5 years. There is no copy of royalty certificate on deposit for the past 5 years. I keep filing representations that investigate this matter. Finally, some investigation is done. My lords will see on the next page. After getting this information, I file a representation to the competent authority, the Deputy Director Mines, that investigate. They have not paid royalty. Now, my lords, see where the first crack, the first substantial crack occurs. And that is pursuant to an inquiry, if my lords has page 78. This is where it gets interesting. Page 78, subject inquiry report on allegation of mine against so and so and so and so under the particular tehsil. In inviting a reference to the subject cited above, I'm saying that a team comprising of officials of the Directorate of Minor Minerals had proceeded to the DDM Talcher office for inquiry into the allegation.
Have you made them a party?
Yes, yes.
Notice.
Yes.
Okay.
Deeply obliged. Would my lords consider a stay at this point?
Oh.
Well, I'll argue it at the appropriate.
Item number 18.
Obligement.
I clear.
ITC is due to non-existence of another entity like such and such, other than such and such, which was not in the knowledge of the petitioner at the time of filing the return. The petitioner claimed need for filing a return, filing and liability details of the same entity as well as GST portal. We did this memo for kind perusal of this. So,
This is the return details and liability details of that particular entity. What the department said, it is non-existent. But what you'll see, if you'll kind have a glance at page 6 of my memo.
yes. Yes.
For this 2024 and 25 period, let's say that is August, liability paid is. That is the second entity that my learned friend says that it is non-existent. If a non-existent dealer has discharged his liability up to 100%. This is the GST
Where
portal
do I get
space
it that it is
of that particular entity also.
yeah, that is the
Cerebral. Yes.
trade exempt.
Yes.
Where do I get it? It is relating to cerebral trade exempt.
Yes, this is GST portal, you will see.
Where do I get the name of this company? Where?
First page, you will see.
Oh, this is the first page.
Cerebral trade exempt.
Yes.
Then page 4 of that memo, you will see. They have filed return and particular for that period, August. Date of filing is 9/9/2024.
Now into the council mode.
Yes.
Yes. The item for result of so
Yes, if it's there is an entity non-existent is not there. They are the
All
GST.
the paper transaction, the report you let me
That's the-
kindly turn to
but
West
he
Bengal.
is- But he is submitting this return showing the GST what he has collected.
Your Lordship, only these are the paper transaction. Your Lordship, may kindly
What
turn
paper
to,
transaction?
turn to the report of the enforcement of West Bengal. Your Lordship.
What the invoice says what? What is the supply? Invoice
Your Lordship.
is what is the supply
The
was made which attracts the GST.
Your Lordship, the invoices have been generated. The way your Lordship may kindly turn to
generated for what?
Turn to the West Bengal report, your Lordship. I have submitted in my instruction. I have enclosed.
First thing is that what are the goods which are sold to him or her?
Your Lordship.
Which attracts a GST.
Your Lordship.
Show me what are the nature of the goods shown in the invoice. You say it was never supplied.
Never
supplied. Please show me the nature of the goods. What has been given in the invoice? Is it a paper? It is a metal? It is something? What?
Invoice has been generated. Your Lordship, invoice has been generated. Waybill has been generated. Your Lordship will not find any mistake. Because it is paper transaction. Even in real transaction, your Lordship can find a mistake. But in paper transaction, your Lordship will not find any mistake, a single mistake. Your Lordship may kindly turn to the report of West Bengal Authority and how this fraud has been. And basing on that report, your Lordship, I have submitted in my
report is gospel. Report is gospel.
It is required to be.
You will not apply one.
Let's see my.
You will not apply one. Your assessing authority will not apply it.
That proceeding has been initiated and that is pending. So
where is the report?
Your Lordship, the report I have enclosed in my that handwritten copy, your Lordship. Handwritten copy. This is the report done in Southwest Bengal in the matter of ongoing investigation conducted against one Arun Verma. The reports are corroborative evidence thereof. It has been revealed that Arun Verma controls the activities of numerous non-functional, non-operational concern which have attained registration under CGST and WB West Bengal. Arun Verma thereafter controls the entire GST portal, UABIL portal, bank account, so and so, either via digital banking system, pre-signed check, ATM.
Having total control of user ID and password.
Arun Verma were aforesaid profile credential to generate fake invoices and fake UABIL for the same concern controlled by against which no physical control, actual supply of the further to make this fake transaction appear real. He transferred through RTGS, NEFT and other various modes along with the defunct concern. The initiation point of each such transfer in a beneficiary concern who after claim the said transaction at his bona fide purchase. Meanwhile, those beneficiary concern claim input tax credit shown against the fake purchases to reduce and set up their outward GST liability in the light of the name as per the authorization given so and so. I understand along with so and so, Cerebral tells both parties proceed to pay a visit to the principal place of business, Cerebral trade agent, and after that another your Lordship Cerebral trade to make an inquiry so far 67 of West Bengal GST Act regarding every existent and functional business activity of the RTP. After reaching at so and so, I find a small shop so and so. I met a gentleman who introduced so and so. We stayed to him purpose of our visit. Then he is the landlord of the said property. These are the investigation, Your Lordship. Like evidently we not find so and so. Then Your Lordship, he has not rented so and so. Even in the meanwhile, this. On the contents of this, so these are the beneficiary. These petitioner is the beneficiary of the two forms.
How's the game? Your Lordship, if we think about this kind of then what is the game? I just wanted to.
Your Lordship, what is the game? Your Lordship, this is a chain.
What is the game?
Gain of what?
A person who is indulged in this kind of a thing.
Your Lordship,
what he gains.
Your Lordship, how the fraud, Your Lordship, provide me 1 minute.
And first elementary ingredient of the fraud is
Your Lordship,
there are certain acts for some personal gain.
Your Lordship,
What I just wanted to know, what is the personal gain?
Your Lordship, how this fraud is going on. Your Lordship, for a moment, Your Lordship, only 2 minutes I can convince Your Lordship. Purchases have been made.
Correct.
Your Lordship,
No, it's okay.
Your Lordship, it is paid.
Not getting pleased.
Your Lordship, may kindly turn to the provision for a moment. Rule 86A. How this is premature, the proceeding is premature, Your Lordship. May kindly look into 86A. And 86A to Your Lordship, may kindly look into this order. Yes, Your Lordship, he can apply for withdrawal of the to revoke the attachment, Your Lordship. And this is the judgment, Your Lordship order, Your Lordship may kindly peruse. And on 86 to 82, Your Lordship, he can approve. He can approve. And also, Your Lordship, show-cause notice have been issued. DRC 01, a free show-cause notice. He can appear before the assessing officer and establish his case, Your Lordship. Because this is entirely premature, Your Lordship, so far as this blocking of ITC is concerned, Your Lordship.
Yes.
May I submit some judgments to that?
Because it is under investigation, Your Lordship. Investigation is going on. That is a report. And based on that report,
Honorable Apex Court has on.
Your Lordship, since I have not filed a counter in this case, I may be permitted to file a small written note within 1 month. Your Lordship. Your Lordship, please.
So far as the assessment and let's say concerned, that is for 21-22. That is 21-22.
Two taxable persons. Only two taxable persons.
Supply.
Only two.
Yes.
Only assessment year what my learned friend submitted in the last occasion, that is for the year 21-22, and this year is 24-25. This is my respective submission. For assessment of 21-22, the document what my learned friend has submitted in the last occasion, GST 01A and 01 has been supplied to uploaded in the portal. That is for 21-22 year. But this particular year is concerning the 24-25.
Blocking is for 24-25, but amount is that.
Yes.
Your Lordship, may I please, Your Lordship?
Item 19.
Your Lordship, here the state.
Item number 23.
Your Lordship, here the state is the petitioner, Your Lordship, has challenged the interlocutory order that the law and tribunal, Your Lordship. Our interlocutory order of the law and tribunal, Your Lordship, the state has challenged that order. Your Lordship, knows I'm not so much of technical, Your Lordship, and as Your Lordship is also very so far as the delay is concerned. But Your Lordship, here 3 years 170 days delay. Your Lordship, may kindly come to the input order, page 21. This is I have my read.
Notice.
And Your Lordship, this is interlocutory. Now the tribunal appeal is pending before tribunal. So the hearing of the tribunal may be stayed.
For the time being.
Your Lordship, I'm grateful.
Order 41, Rule 3, capital A of the code. Sub Rule 5.
Your Lordship, hearing of the tribunal may be stayed. I'm not praying any stay against the petitioner, against the dealer.
He understood your submission, and for that submission, I am referring this problem.
Enter error apparent on the face of record, Your Lordship. I can establish, Your Lordship, that farm is continuing, but amended is GST, Your Lordship. Every month, yes, file GST.
One is Sub 3.
Your Lordship, Your Lordship.
Rule 3A, capital.
Your Lordship.
You read.
Your Lordship, when an appeal is presented after the expiry of period of limitations specified, therefore, it shall be accompanied by an application supported by affidavit setting forth of the facts on which the appellant rectified to satisfy the court that he had sufficient cause for not preparing the appeal within such period. If the court see no reason to reject the application without the issue of notice, Your Lordship, where an application has been made under sub-rule 1, the court shall not make an order for the stay of execution of the decree against which the appeal is proposed to be filed, so long as the court does not, after hearing under Rule 11, decide to hear the appeal.
So condonation has to be done unless the condonation was state.
Your Lordship,
That is the your condonation has not been allowed.
No, condonation has been allowed of the deal, which should not have been allowed. And error apparent on the face of record.
Any
Your Lordship, notice.
Notice.
Your Lordship.
Item 24.
It has covered matter relating to GST.
Cancellation.
Connected there.
10%.
No. Cancellation of the registry. Cancellation of the registry.
Item 2, I'm attending.
Item 25.
Item 25, Your Lordship, it's regarding registration cancellation. I have already submitted the order and signature of the others. Already been endorsed.
Item 26.
Matter may be taken up 1 week after.
This is a case, this was the direction by Honorable Supreme Court, where there is a in the liberty to the appellant that to file the petition for releasing some amount. Your lordship has directed the state government to file their objection at the request. We have, they have filed the objection, we have filed the reply also. In the last date on 18th, they took time. On second, your lordship, since we are on leave, the matter has come up today. My submission is that your lordship may release some amount so that I can meet my expenses.
Then,
Then,
one week up. London AG will appear in this case.
That was also, the request was made to adjourn it, since I was not available on second, so it could not be taken. When you want, give me a date, then you have to. There is a direction for the Supreme Court for the.
Any date after 21st. Any date after 21st.
Put it on 22nd.
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 No adjournment.
No adjournment.
On 22nd, maybe.
Yes.
No, my lord, so long I am coming from Delhi.
I appreciate your agony. On the prayer, 22nd.
My lord, that your lordship may please to
Now
release some
let us
amount.
specifically fix matter. First matter, don't worry.
My lord.
As a specially fixed matter, so that it will be taken up far.
My lord, yes, my lord.
Okay.
Your lordship may at least release some amount so that it will.
We will definitely use the full amount.
Okay, ma'am. Okay.
For the
All
amount.
right,
very good.
Item 27.
I'm asking for copy number 213.
What?
We kindly permitted to withdraw your loss.
Why?
Yes, the petitioner doesn't want to copy.
Memo is.
Answer the petition.
Both the cases. Not yeah. Item 28.
Both the matters you want to withdraw?
Yes, sir. Yeah, please, Ma'am. This review petition, I am seeking review of the order filed by this honorable court, Madam.
Where is the order?
It's annexure A1. It's starting with page 33. My lord, there is apparent.
And this my brother first.
Yes, ma'am. Manas, there is a apparent wrong recording of facts in the order. Manas, kindly have turned to page 41, madam.
What is the
Yes, ma'am. Yes, madam. What has happened is, madam, this was there was an examination conducted by opposite party number 1 for the appointment of contractual for the appointment of lecturers in aided colleges, madam. I appeared in the examination. I scored 87.5. And when the key answer key was published, and we were given the opportunity, the candidates who appeared to raise objections. I raised objection with regard to 4 questions. However, those questions out and other people raised objection with regard to other questions. Now, I made a petition for them to consider my objection. That was not considered. I filed a writ petition. When they said that writ petition is my lord. Writ petition 387. Yes, my lord.
We are not concerned. Then what happened to that?
Writ petition, this honorable single judge directed disposed of the writ petition with the direction that
you consider it.
Yes, my lord. Then it was not favorably considered. I filed another writ petition, ma'am. In that writ petition, the honorable single judge directed the reevaluations of the questions, disputed questions in the writ petition by an independent body constituted under the direction of this honorable court from the head of the faculties.
Whatever.
From the university.
Special independent committee or
yes. Yes. That they submitted the report in the sealed cover. The sealed cover was opened, and out of 4 questions, 3 questions were accepted. The independent committee accepted that my answers were right. To that report, they filed the opposite party filed a additional affidavit saying that
three questions, what could be, there could be two, multiple answers to the questions, and the answers selected by the opposite party, as well as the answer given by me and found to be correct by the independent committee, both could be correct. However, marks can't be granted to me for the purpose of extending the benefit of appearing in the viva voice, as I will not be able to secure the entire 25 marks, which is required to make the cutoff for the panelist. And on this presumption, the
they found that the three questions.
Yes, ma'am.
One they discarded. They did
Yes.
not accept your condition.
Yes, yes.
The probable answer what you propose is there.
Is there.
And apart, they say that apart from that, there is also a probability of correctness of the answer, so far as the other options are there.
Yes, ma'am.
Then what they did?
They filed an additional affidavit saying that both the answer could be correct. On that basis, Honorable Single Judge allowed my repetition, gave them the direction to conduct a viva voice for me, and if I am found eligible, give me recommend my name for the appointment. This order was challenged before the Honorable Division Bench. In the and I was appearing in person, my lord, and on the very first day, I mean.
You never appeared. You never.
In person.
You never appeared.
I am not first. I am not first. Now, what has happened before this honorable the division, before the honorable division bench? This was portrayed as if I have been improving my stand.
There's no comment. Who appeared?
No one is finally see
for the petitioner.
No
Sanjeev Kumar Das. No. Oh, that was the selection board.
You were responding.
Oh, you were responding.
Responded in person.
Yes, yes. Then
impression was created that I have been changing my stance. That initially I was agitated, disputing some other questions. In the second repetition, I disputed some other questions, and that is the first thing that impression was created upon my lords. On that basis, the discussion has been recorded by this honorable court.
So what transpired during the course of
the hearing?
You were not present.
Yeah, I am not present. As a counsel, I was not present. My client was appearing in person.
So can your client maintain a review to you to convince the court that what transpires on the day was not actually correct?
No, I'm on the ground that review maintainable on the ground that there is an apparent error that has crept into the order.
What is the nature of an error?
Yes, ma'am.
Error is that submissions which your client advanced was not correctly recorded.
No, my lords, the submission, my lords, very frankly, my lords, I am not aware what transpired during the course of hearing when the writ appeal was disposed of. However, I have read the order which is impugned before my lords, where they say, my lords, the recording of fact is that I have been changing the question numbers. I am disputing different question at different stage. That is, my lord, incorrect from the records itself. If my lords permit me, I can show this page numbers, my lord. Second thing, my lords, the issue was raised that if the rules don't permit, then reevaluation cannot be directed. My lords, I am not sure
You
that
accepted. You accepted that reevaluation for the receivable.
Sorry, ma'am, I couldn't follow.
Reevaluation.
Yes, ma'am.
You accepted that position.
Because I wanted the reevaluation. So, what the impugn order says that reevaluation cannot be permitted as directed by the honorable single judge in absence of rules. If the rules don't permit, then you cannot do it. Correct. That is one thing. However, where my contention is that their own affidavit they are saying that there are two answers which are possible. One of the option is selected by me.
The question is the reevaluation cannot be done in absence of any express provision in the rules.
Right.
Right. So even if they admit, if the rules does not permit, then can it be done or can direct on the basis of the consensus? Divorce the rules. I am asking.
Here rules my lords, when they say that they are two.
I'm again saying, if the rule does not confer power on a particular authority to do a particular thing, even an authority admits that yes, it was, I want to do it, can the court direct him to do it? I'm asking you.
My lords,
Can the court defy the statutory provision?
my lords,
Mere consent or mere admission, I'm asking.
my lords,
Question of law.
yes, my lords, I
Then I'm reminding you of the old English judgment of Legard versus Bull.
my lords, I beg to answer that question by putting a question to myself. If the
I'm taking you, suppose the act is in place, which does not contain any provision that an authority can change his decision. Somebody came before the court and the authority said that, yes, I can change my decision. Can the court direct him to change the decision? I am just asking. Very simple.
Yes, my lord. I'm trying to answer that questions fell from my lords, my lord. My lords, if my lords' hands are tied, my lords can't proceed against the law, but then action is arbitrary, manifestly arbitrary.
This is arbitrary.
Because my lords, these two questions are because Supreme Court has.
This is wrong, sir.
My lords, yes, my lord, on limitations.
How many days do you?
There is a delay of 180.
But you have not mentioned that in your.
My lord, it's I
You have not mentioned that in your petition. How many days? You have not counted. Nebulously.
And yes, my lord,
Your petition itself is defective. Limitation petition itself is defective.
Sir, you must remember the jurisdiction concerning the review exercised by the court. It is on a 3 grounds only. One is, if there is an error apparent on the face of the record, the court can review the error. Second one is discovery of new and important documents which with the due diligence was not within the knowledge of the decision at the time of filing. And the third one is for any other substantial reasons. The third one has been interpreted constantly by the apex court and the High Court that it is not an independent one, but a relatable to first two options. You are talking about the error apparent on the face of the record. The error must be of such magnanimity or a magnitude which would really tilt the entire decision diametrically opposite. Where error of a fringe things does not mean it is an error apparent on the face of the record.
This one I completely bow down to that.
Secondly, there is a really real distinction between an erroneous order and order tainted with an error apparent on the face of it.
Yes.
Erroneous order is amenable to be challenged by way of an appeal. The review does not know. If there is a wrong proposition of law, if there is something which has been decided, then it's erroneous. You go and get it corrected by moving a higher. But the court cannot intervene. You are really inviting the court to revisit the entire issue, to rethink over the matter, to rewrite the judgment, which is impermissible in a review jurisdiction.
That's my only end of
what is there and whatever is there, in whether the rules are there or not there. If the court has held that in absence of any rules, I will not direct them to re-evaluate the answer. That's the decision, which may be erroneous. It is not an error apparent on the face of the record. This is what is the perception and the decision of the bench.
which may be correct, which may not be correct, test it in, go by going higher.
My lords, only I completely bow down to my lord.
No.
What is what only thing is
Have
whether
you read the Tungabhadra's judgment of the Supreme Court, that's the classical judgment on the review?
my lords, I have not read that.
Please read, when you come and argue the review, then you should read that particular Tungabhadra's judgment of the Supreme Court.
Only endeavor that I am trying to make is that whether at the time of passing of that impugn order, whether
And
the
you were
affidavit-
not there.
I was
You were not there. Then also read AIR 1997 Supreme Court page 1005.
my lords,
I would beseech you to read that judgment.
my lords,
And the language used by the Supreme Court.
Over and above everything, first of all, you should have been very fair to say that there was limitation. First, unless we overcome that hurdle, how can we hear the merit of it?
yes, my lord, completely my lords. And
So you should have.
actually,
Your fiction itself is defective. Come to para 3.
yes,
Let's see. Para 3, you read.
yes, no.
That is the only reason you have cited.
My lords, I completely bow down, my lords, and I apologize that it is not.
Read it aloud.
The impugn order was passed on 38/2024. The petitioner, after receipt of the certified copy, sought for legal opinion for preferring the present review petition, and in the process there has been an inadvertent delay of my lords.
There's a sufficient cause.
No, my lords, I am tendering my apologies, additional apologies. I completely bow down, my lord. This is not happily worded, but my lords, the reasons are.
So the court should shut his eyes, will also shut his mind.
I am seeking.
And then pass the order.
I am only
condoning the
seeking-
delay.
I am-
It's on a drop of a hat, the court will condone the delay. What may come, whatever be the reasons. Not difficult. Section 5 has meaning as
No,
has
my
no
lord.
valuable, meaningless provision.
Section 5 can be
What is theirs?
My lord,
Why the court will apply?
I am
its
only
right?
seeking the compassionate consideration of this issue, my lord, because
That's a passion with the bona fide.
compassion with the bona fide.
No empathy, no sympathy, nor a compassion will dilute the rigor of the provision of law. Can it? Then
My lords,
show me the law, that the empathy, sympathy, compassion, everything will dilute the rigor of a law. The law should be kept aside.
my lords, my only endeavor was whether at the time of passing of the impugn order, their affidavit was considered.
No. You have to pass the muster of section first. I didn't know because you came and started the review.
My lords, I apologize. I should have
My
at the
brother,
very
because I never looked at the file.
at the very threshold I should have
My
informed the court. my
brother,
lord.
now you'll have to convince my brother.
My lords, if my lord may permit me to file a better affidavit, my lord, or condemnation of delay. my lord.
That's something.
No, that's it.
My lord, because their affidavit is quite clear, my lords. They have themselves have admitted that what are the answers to the then I would only beseech my lord to permit me to file a
With heavy cost for cavalier drafting and filing it before court. Heavy cost and dismiss.
plus cost may not be
With
imposed.
certain judgments referred.
My lords. Cost may not be imposed, my lord. He was appearing in person.
Definitely, heavy cost. You are in review.
Plus he is, I mean,
You are in review, that too, you were not the counsel. And I was member of that bench.
And
And you have said the author of the judgment went wrong. So I have to revisit.
I'm only saying
You are
that was not
forcing me to
brought.
revisit that judgment,
Minus neither in my
which I agree.
minus neither in my submissions nor in the pleadings I have ever said. Our only thing is that time whether their affidavit was brought to the notice of this honorable court. That is.
Have you read Sri Jagannath Temple Administration case? Review. I have delivered along with other other chief justices. Or something. Info past. There was no delay. For change of lawyers. Many judgments are referred to there.
Others may not be told the purpose.
Review and
I tender my
by a petition which is so casually drafted. You are not mentioned even what is the period of delay in your petition. After I pointed out, you are coming up.
In the prayer clause, it is mentioned, however, it has left the paragraph number 3. Prayer, it is mentioned, and I tender my most sincerest apologies for this, that purpose.
What is there?
Then either permit me to withdraw or
no liberal.
And if my lords are wishing to
no liberal.
Permit me to withdraw. Permit me to withdraw.
Withdraw.
But
It's your choice.
Otherwise, I cannot.
It's your choice, sir. Subject to.
Would we seek
justice?
Let me withdraw it and file come up with a better application.
Withdraw entire thing. Not this.
One more thing, this order has been already challenged before the Honorable Supreme Court, and Honorable Supreme Court has also dismissed the SLP matters. However, I am covered by. No matters. Supreme Court judgment is.
Judgment. I'm saying 2000 volume 6.
That has been reiterated. That position has been reiterated in the coded distillery.
It has been reiterated and says no merger. I am conscious.
Yes,
no merger.
And the jury.
But the court will not shut its eyes.
But my lords, in the said judgment of the Honorable Supreme Court,
it has been referred. I think it has been referred to a larger bench by the Supreme. Whether the review after the dismissal.
My lords, in this coded distillery, the Honorable Supreme Court has said that unless and until the leave is granted, jurisdiction to entertain.
That was a concept of a merger.
Yes, my lord, it is on the doctrine of merger.
Whether it will merge with the order of the says that the assembly state no merger.
No merger.
Second, it says that even if the notice is given without recording any reasons, no merger. Once the notice is given and then certain observations have been made, maybe in a very concise or specific form, it will invite merger. And if after full-fledged hearing and the
leave is granted, then it is merger.
Obviously.
Yes, no.
When it originates from a very off-putted Supreme Court judgment, first judgment is Boje Brothers case. On a doctrinal must have been in court discovery, must have been considered Boje Brothers case.
Yes.
Must have been considered. That's the first judgment.
Funds permit me to withdraw money. That's it, you will fund me to-
By your mind.
Permit me to withdraw money. If my lordship
Taking the risk. Or should be dismissed only on the ground of delay.
this is all the ground of delay.
That would save you.
Item 29.
Highly obliged.
The comprehensive litigation matter where the land of the Konica was under the Konica Loza matter.
Did not understand.
And in this matter, they have filed an application for amendment. Copy is not sought for.
My responsibility matter that is the case of land, ceiling land. In 74, ceiling surplus land, that is government land.
I have not understood, Mane, what is the, what for you have filed this application?
And the land
This petition.
lands, number of lands are not included in ceiling land.
Ceiling means?
Ceiling means the Zamindar and Roja was acquiring the land after the land reform.
Land Reforms Act.
That was
So there is a ceiling limit that
yes, ma'am, yes,
the person cannot hold beyond that.
That is the yes, ma'am, that is limited. And the case was in 1974.
This was?
1974, man. Since ceiling was
1974.
Ceiling was initiated. And time to time, the ceiling was not finalized. Therefore, the ceiling holder and his legal heirs continuously sold the ceiling surplus land. Those are the dollars.
Suppose I'm just not read the state law. I'm just asking because I have a different notion.
Yes, ma'am. Yes.
I know. From that notion, I'm asking this.
Yes, ma'am.
If the Land Reforms Act was enacted at the state, then if they put a ceiling limit beyond which one cannot, then anybody who was possessing a land beyond the ceiling limit, is there any provision in the Land Reforms Act that the surplus land would vest to the state?
Yes, ma'am.
Vesting provision is there.
Yes, there is
that it will vest to the state.
Yes, ma'am.
Correct. If was there any provision for retention?
Yes, ma'am.
That so much of land which they want within the ceiling limit, they can identify those lands to be retained by them.
Yes, yes.
The other lands be.
Therefore, he has submitted submission of returns, ma'am.
Yes.
But he has not submitted return. And
Let's suppose if the ceiling limit they are typically is a 10 hectares of land.
10 acres land.
Right. Ceiling limit is 10 hectares of land. He is possessing 15 hectares of land.
Yes, ma'am.
So 5 hectares are surplus.
Yes, ma'am.
If he is selling 2 hectares of land, can you blame him? That
No, ma'am.
So
In the case, the ceiling limit is only 10 acres, ma'am. That is standard acre. That is 30 acres, ma'am. But the king have the property of the more than 3,000 acres. And number of trusts are there. Number of illegal trusts, madam. Therefore, the
trust means
private trust, that is the private trust, that is public trust is exempted by the.
Is there any distinction that if there is a trust, it has a separate entity and does not come within the individual?
Yes, ma'am. As per the provision, if a public trust, which was exempted from the ceiling, ma'am. If the public trust and the.
No, please, you have not understood the, what is playing. Is there any bar that the private trust cannot hold the land?
As per this land.
No bar?
No.
Is there any bar that the private trust cannot acquire the property or hold the property?
Not acquire the property, acquire the ceiling, ma'am. That is the ceiling surplus land.
I am asking you, you are not understanding. In the Land Reforms Act, is there any bar that the private trust cannot hold the property or cannot purchase the property, cannot acquire the property?
There is a bar.
Complete bar on a private trust.
Complete bar.
It is one thing that the public trust will not come within the purview of the ceiling provision. That is the different thing.
That is different thing.
That means if public trust can hold the property.
Yes, ma'am.
Then analogy is whether the private trust can hold the property or cannot hold the property.
No, cannot hold.
Within the ceiling limit.
Within the ceiling.
Can he hold the property or cannot hold within the ceiling limit?
Cannot hold.
At all.
At all.
Not even a 1 inch of the property.
Beyond ceiling limit.
Oh. Correct?
Yes.
So within the ceiling limit, private trust can hold.
Yes, ma'am.
Then the private trust is an independent entity in line of law. Then he will be regarded as an individual holding the property.
Yes, my individual holding.
Correct?
Yes.
Up to the ceiling limit, he can hold the property.
Beyond ceiling limit, ma'am. And that is ceiling limit. My responsibility. I explain.
I think this was not able to convince us. Convey money.
My expression, the ceiling limit is 30 acres.
Is there any provision relating to adjudication of the disputes like this nature by a revenue officer or anybody?
Revenue officer.
There is.
Yes.
I told the revenue officer.
Already approached, 3 times ceiling are decided, man.
Is there any provision for an appeal to be filed any of the orders?
There is no, as per the ceiling, there is no appeal, man. But I am the public.
Against any order of the revenue officer. Is there any provision for an appeal?
The remedy is there, my lord, but the remedy is there. So who is affected and the ceiling is there. But the persons, as I am the concern for public, my lord. Mind that the lands, those are affected from the ceiling limit, my lord, who has purchased or
acquiring this right.
The public interest.
Public interest.
Can you, who are you?
I am-
The doctors has no role to play. Now tell me, then who are you?
My lord, my responsible submission, my lord.
Who are you?
I am the general public of Tonica.
General. Of?
Of Tonica, the owner of the estate king is situated, my lord. So in the district of Kendapura.
You are the general person. Can you maintain a writ for a specific purpose?
One of the illegality committed by the revenue officer, excluding the number of properties, not including the ceiling surplus, and illegally included the lands which was.
That's you can approach the proper authority for.
Whom I approach? That is the case. That is the case.
Officer inviting his attention that these are the lands which are surplus. Please declare those to have been vested with the government.
I agree with your attention, my lord. Initially in 2004, 2087, this ceiling was decided. Then the collector of the district, my lord, filed a division before the board of revenue. At the Annex 2, my lord, the board of revenue then declared that the land included in the two trusts, that is more near about to 200 acres, are declared as not public trust, that is a private trust, that is should be included in the ceiling surplus. Therefore, this order was challenged before this honorable board. This honorable board is confirmed the order of the board of revenue, and thus that order also challenged before the Supreme Court. Thus, same was confirmed. Then now in 2004, my lord, the ceiling are again decided. And those land included in the public two trusts, that is the Tonica Museum Trust and the Botanical Garden Trust, was declared as ceiling surplus in 2004. But no, the same land has not been recorded in favor of the government.
Go before the
That
is your personal interest.
My lord, that
is projected through a PIL.
My lord, my responsible submission, my lord. The government and the ceiling holder, the case between the Land Reforms Act, revenue officer had initiated the ceiling case, man. And the opposite party is ceiling holder, man. And no third party is there.
Why there should be a third party?
Therefore, what the government authority had taken negligence matter in 74, had facilitated the ceiling holders and his legal heirs to sold the government property. Those are ceiling surplus lands. And if those properties are in my area, that is my public, therefore I am public, which are utilized by the public. The number of gardens and like the mango gardens and cashew gardens, a number of properties are there. That is public property, and therefore the public, that is government property, man. The due to ceiling surplus, but which was not recorded in favor of the government.
It's a government property. It's not a public.
Government property. If government property automatically benefited for the public, man. But that shall will not be corrected in favor of the government. And
government can settle that particular surplus land in favor of.
Yes, madam. Yes, madam. Even though earlier this PIL was filed, and the honorable
go before the revenue officer and raise the issue. Why the public?
As per the direction of this honorable court, my lord, I filed the grievance, my lord, as per the Annex 1, my lord. My grievance has not taken into consideration, my lord.
So PIL. Then you have the ordinary writ remedy is available.
My lord, while this
ordinary writ remedy is available to you, you can go for a writ of quo warranto, you can go for a writ of mandamus, but why the PIL?
My lord, my response, my lord, when this honorable court has earlier decided this case, order letter 11/9/2023, my lord, had directed to the revenue officer and given up liberty, my lord.
I have to be very simple. This kind of situation where
no matter that is the
the authority in the PIL. That is the first prayer.
That's the duty of state, madam. But state was taking.
Sir, you can definitely go and say that I am a person affected. If you challenge the particular order, then to seek a leave and then challenge the order. In PIL, can the order be challenged? Please satisfy me.
My explanation.
Because I have a different notion of the public interest litigation.
Yes, ma'am. Yes, ma'am.
Satisfy me that this kind of cases also comes within the PIL. Show me the law.
That is the duty. Government land is involved in this.
Sir, show me the law. PIL is not a statutory right, nor a statutory remedy. It is a judge-made law. By virtue of the pronouncement of several judgments, the concept of public interest litigation has originated. Show me that these type of cases can come where you can challenge a particular order in a PI. I do not know. My mind is still open. If you convince me, I am ready.
Yes, madam. I am ready to convince, madam. Some time we given.
Whatever time you take. Right from 1980, S.P. Gupta,
yes, madam.
Please come on the line of judgments of the PI.
Yes, madam. I from prepare and satisfied also. Yes.
Bandhua Mocha, judgment you come, all the PIL, how much has to be done.
Yes, ma'am. Given option, I will satisfy.
What you think is reasonable to you?
Yes, ma'am. Who is time?
Note it.
Yes.
Who is?
Well.
The query. Come with those line of judgment, please satisfy my, it is our conscience that the PIL would lack. Our mind is still open, sir. Don't worry.
Item 30.
The IAs have been filed which have not copied of my served on us. Because the additional affidavit filed yesterday copies.
You are not a party to it, you read the receipt is here. No, we have that.
Series number. Series number.
No, that is so. Yes. Electronic mode of service, that is so.
Physical.
But you have to serve hard copy.
Physically, lots of receipts. Yes, is a lot.
Show yes. That physical copy is given.
Your office must not have.
Yesterday,
Your office. Now there was a problem.
No, I can understand. It's a big office. It's Freedom's office is very big.
Additional affidavit. Additional affidavit.
Fully we are not accustomed to that.
It's very big and I can understand the difficulty.
The additional affidavit is not been proper.
I has been solved, no? Additional.
Yeah, we just say that. Additional affidavit.
There are two IAs.
The additional affidavit now there's
There are two IAs, whether both the IAs have been served.
Yes, it's what. It is.
3 IAs.
Oh, three IAs.
One is originally Miller at the time of filing, subsequently 2 IAs filed. One for amendment.
One of they are on record, so three have to be served. All served.
Yes, sir.
The additional affidavit has been served right now. And your lordship, I'd like to apprise your lordship that on 30/6/2025, the present tender who is attending to that aquarium is taken a stay order of tender matters in the civil bench, your lordship.
Then petitioner.
No, your lordship, the one who is continuing.
Present tender is not the one who was continuing.
The tender was continuing. The present person who is.
You say present tender.
No, who is looking for the aquarium, I said. You are not looking at it.
The other person.
The other side. The maintenance job, your lordship. Taken a stay order on 36. The tender matters.
What's the kind of person? You have a list of something?
No other decision has been taken by the state.
That is an instruction, your lordship.
That may be a separate issue.
Not separate issue, directly touching upon this issue. Have you seen? Look at the order. More particularly the second page and the last sentence.
He's the extension. My gosh. No, but what niceties of this one.
You can't go, you can't enter. Being an L1, cannot touch anything.
No, my friend is L1. I am challenging his.
Whatever, all of you are now in limbo. Both L1 and L2.
Because in the morning also we got information that they have not been allowed to start the work because of.
No, they will not. How can you?
Because of
this order, the last
It
sentence.
appears there's a direct order of this court.
Last sentence.
may not be receiving. Petitioner in that case may not be receiving.
You are not great party there.
No, our instruction came from the.
Neither my friend nor.
Now you come to know this order.
Yes, madam. This order we were not.
Take a decision.
Yes, we are.
They are not, they will not take. You take a decision.
Deviation of that order.
We will take instructions upon that.
I see. Every fringe issue, the state comes. Such a vital point that the state is sitting tight.
Aware of it when the department came.
They should have actually, ideally, they should have disposed it off.
No.
The order is still.
I cannot express my mind in it.
Now let's bereft of the interim prayer. Can I just address your lordship 2 minutes on the
What for?
on the merits of the.
It merits, suppose if the entire tender process is scrapped,
Man.
what will happen?
Then
Indirectly, that will give an impetus.
that will also hit
If
him.
it is dismissed,
Then he will
then
get a-
directly he is not in a position to run. Both ways. Both of you are kept outside. What to do?
Now this is a catch-22 situation.
That is what I am saying. So that's why either of, not you, either of these two have to take a call.
I have a small suggestion, subject to your lordship's acceptance, other way, Manoj. Our amendment may be allowed that that challenging his work order, formal amendment that we had filed on that day. The amendment may be allowed, pleadings may be completed, the matter will be called on around 24th or 25th. Till then,
they will not.
But some kind of, supposing the difficulty is if they decide one of these days and the matter is not on board, then they will immediately insert the other gentleman. And my writ becomes infructuous. So I will be left in a limbo. Despite the fact that I am here before your lordships and I have viewed it virtually.
Where is the application for the amendment?
Amendment is there.
A19
Flag B. Flag B.
Flag B.
738. At flag B. 738. One is a flag B.
Item 30.
Even if the work product that you have formal amendment.
What is this application?
Flag B.
Take my copy.
An application for, we are allowing it for your benefit also. This is an application for amendment
After a week, or what I say?
On 25th.
After a week.
Can I pray for 25th one? Up to 22nd.
Find out.
Because up to 22nd, I am not in town, so I was thinking maybe after 23rd.
28.
23rd.
Carried out or something more activity.
With the liberty, can I, since your lordship is with the liberty, my lords, that we may be given the liberty to make an urgent mention if the other one is disposed of, because our entry is there, but otherwise the writ will become infirm.
What other one is disposed? What, which other one?
The representation that's divided.
That is not a subject matter of the challenge before us. We can't make any observations on.
That's it. No, I've ordered, just give us the liberty to make a mention in the event.
No, definitely not. 1 week after, the matter will come, we'll see to it, what happens. It is their wisdom, his wisdom and their wisdom. What to do?
Because the matter may be fixed to 23rd, because after 24th.
28th.
Senior would
28th,
not from 20. My senior would not be available. 20. I'm saying for 23rd.
23rd is fine.
Not possible. He says that there are a lot of matters which has already been.
Then after 4th of August, my senior would not be available from 28th to 4th. As per my
7th August. 7th August.
7th
August. Item 31. This one.
Good.
Item 32.
There is no entry model in the matter.
No, that is
First placement.
Don't see the matter. But 32.
Item 32.
Yes, sir. Who is appearing? Mr. Yes, where are you? What is this? More complicated points that comes from your end. What is the matter? Tell me, notification was. Modification in what?
Paragraph 6 is saying, I have read for 40 hours. 6
What?
and 7. 6 and 7. 6 and 7. Page 3 and paragraph 4, 5. Paragraph 4 and 5. Usage are given now.
This is given to you to assume that ordering of the.
At paragraph 4 and 5, it also please to say that admittedly that was not solved in the notice as well as the order was solved on the same day.
So it was served upon the another advocate who represented the company on 28/3.
Yes, that's it.
So they admitted that it could not be served. So the court has recorded that.
Yes,
So
that's
what is the
that is-
difficulty?
Because let's say I was not hard, let's say.
What hard?
So course notice on the order on the same
Sir,
day.
the court has says that the petition is not the same as reflected in the show cause notice. This is what was submitted by you. It says that the said document reveals that the address of the petitioner is not the same as reflected in the show cause notice. That's why it could not be, we presumed it was not served. But we directed this to service to have been affected or through lawyer.
What has happened on 23, 2025?
the advocate appeal, we have solved it.
Yes.
And after.
That is what you submit.
Yes, ma'am. Yes, ma'am. That is advocate right.
Yeah,
And the
yeah,
solicitor
sir.
is not disputing also. Now, what he is doing, that as no natural justice was provided to them for hearing of the so-called notice, that's why order may be modified to that extent.
No, this is the revisitation. There's nothing, no, modification is never intended. Never intended. You're really seeking a review of the.
That particular day, Lordship has been pleased to say that when order goes, nothing remains. And
No.
in the order, actually.
You are seeking a review of the order which is not in the garb of the modification. What is it? There are judgments against you.
Also, if your lordship will come to para 6, fifth line, since the advocate for the petitioner as well as the senior standing counsel for the department considered that the order in original is served on the advocate for the petitioner on in view of the existence of alternative remedy under the Finance Act 1994, the petitioner is not liberty to file on to assess that order before the appropriate forum within a period of.
But para 5.1, Lordship, please do record that.
No. This is an application. This is an application seeking modification of
Item note 33.
Item 31, liberties contribution. Liberty to pay letter, please. The item given, item 31.
You have filed a memo, sought for liberty.
Let me go.
Item 33.
Item 33, I am appealing for the respondent. I am appealing to the respondent, ma'am.
I am appealing for appellate. I have submitted by 17, number 17, 25 for condonation of delay, and there was delay of 2 months.
Delay may be condemned, my lord. My limited favor lordship. I am a retired employee. As per honorable application of the and the judgment of our own High Court, my gratuity cannot be withheld actually. That is what they have done it. And everywhere I have succeeded.
Yes, definitely. How can you withhold the gratuity in the absence of any statutory ground?
Yes, ma'am. That is only the point.
My submission, and the concerned respondent is, my lord, a habitual offender. Wherever he was posted, he has committed misappropriation.
Whatever, sir. How can you withhold? Have you initiated any the departmental?
Yes, my lord.
Was it what the departmental proceeding culminated into an order of removal or a termination?
No.
Before the superannuation? No. Then how can you withhold?
And vigilance case, my lord, is
maybe you do not know. Is this a case of a financial embezzlement?
There must be, my lord.
Financial irregularity?
Misappropriation, financial irregularity.
Financial irregularity. Is there any provision in the statute? I know there are provisions where one can withhold a certain amount or a percentage, but show us the provision.
As per the Gratuity Act, my lord,
you can't. Under the Gratuity Act, payment of Gratuity Act, there is no provisions.
Staff search,
but there are provisions in the service code.
Yes,
in some of these states, I do not know here.
In one case, my lord, Mahanadi Courts is limited. There is a rule. Where
there is a rule. That's I know. There is a rule.
My lord, in the staff service rule for the that is we call it human resource policy for this central cooperative bank, approved by the register under section 633 of Orissa Cooperative Society that in case of punishment, the rules of OCA, Orissa classification and appeal rule will be followed.
Till this time, you have not held him guilty. No? Now you cannot remove. Please realize, now you cannot remove him from service. He has already attained superannuation. So you cannot impose that. Secondly, you can definitely withhold the pension, provided there is a provision for withholding of the pension.
But my lord, I appeal to the wisdom, judicial wisdom, that this type of cases are going on. So where we end? I appeal to the wisdom of the
is that when you initiate a proceeding, you should bring it to an end before he demit.
Before he retires.
That is what before he demit the office. I stopped at demit.
Just after retirement, they are filing cases in under PG Act and those
obviously those are the rights because you can't term them as the employee. Now you cannot put him under suspension, nor you can terminate because he has attained the superannuation. Can you?
3-4 cases.
Then who is to be blamed? Who is to be blamed?
The authority
who is retrospect, who is to be blamed?
Sir, with little permission, sir, with humble permission, it is the authority who is formulating the staff service rule. If I am
understand, sir, I understand. I am seeing if there is a statutory provision, no difficulty. If there is none, how can you withhold?
But with humble submission, judiciary having the authority, they can direct the statutory authority for. In the cases are so rampant.
It's a very nice submission. Can the judiciary make the law?
judiciary, under the power of judicial review, if the judiciary has got the power to review. Legislate. So it is a statutory, it is not a legislation. The staff service rule is a executive.
Can a writ jurisdiction be extended? I am reminded of a Mallikarjun judgment of the Supreme Court. Supreme Court deprecated that you can't do it beyond the scope of Article 2.
But I appeal to the judicial.
You can't command that you legislate or you legislate.
When there is some deficiency in the act, so
There is.
it is not an act, it is an executive.
I'm conscious of the Visakha case before the act was placed. I'm conscious.
So this is not the lone case. So a number of cases, hundreds of cases of that. So the employee who is.
Sir, it is you who have to take a call, sir. You are an authority. You are a cooperative society. You are covered by the Orissa Cooperative Societies Act. You know you have a power. What powers you can exercise, you do it. Why you put a gun on the shoulder of a court and you wanted the court to trigger?
My lord, while the payment of gratuity under the.
Now he has a secret. Is an application for condonation of delay.
Don't hold everything. All the decisions are taken care. Despite all, they are not releasing money.
Yeah, my friend, senior friend has whatever he has mentioned, presenter, I admit. But only one point, neither the appellate authority on the payment of gratuity act nor honorable single judge has cited the reason why an employee committing serious misappropriation financial irregularities, why it has not been dealt in the portion of the judgment. Why? Because we mentioned this point vividly in both.
Very interesting point you are raising. I am really enlightened by that. Can a person be termed as guilty of doing a certain things unless he is held guilty?
No. Till the logical conclusion is not drawn, he can't.
How can you? Then what consideration the court will do? Is it not prejudging an issue? Amounting to a likelihood of bias? So, why the court will say, you have not, till now, you have not held him guilty. Then why the court will accept that he is a guilty? The irony of the thing is that you will not do anything, but you wanted everything to be done by the court. You do it. You are the appointing office. You are a disciplinary authority. It is you who have to take. Why the court will step into.
My lord, he superintended on 28/3/2013. He joined 1981, retired in the year 2013.
So after producing the in view of the stand to taking.
Item 34.
Well, that's another time passing. Let me try to pick.
What process is that?
36. No, 35 already done. What's your block? 36 please. 36 now.
Service.
37.
Hearing for the bank respondents, which my name is 35. They petition the appeal has he filed with and what we have started inquiry in terms of the order of the signature. So therefore,
The other side is not here, sir. He has withdrawn his.
he has filed a memo.
Yes, that has been withdrawn. That has in the morning it has been done.
Therefore, you go back.
Yes.
Your name will be recorded. That's all.
That's why I am filing.
Say that my name be recorded. That's all.
Because
No, because he is known to me.
Yeah.
In the evening, what you will do is known to me. Don't worry. Do it. Yes. Next.
Item 37.
David already objection to my application to delay condemnation. Yesterday I have received it.
Yeah.
Yesterday I have received the application filed by the state.
So what do you want?
3 periods time now. It like previous time.
For what? To peruse.
No, I've already perused lordship. The cited decision is 421 days delay in filing of this appeal lordship.
What do you want the 3 days time? You want to file a rejoinder or you want? You want to prepare yourself.
See, judgment sought to be
Come on
challenged.
Tuesday.
Well,
The judgment sought to be challenged in the present appeal arises out of a common disposal of writ applications. In one of the cases, writ appeal was preferred and
item 38.
confirmed.
Come. You want to try.
38.
My repeats were allowed. And all clear means all clear was allowed, but there was no direction for payment of main trial. It was payment of regulation of my substance, other structures and concepts.
This was taken up.
Committed the decision.
Orders. You just send it.
Fine.
Your document passed.
Yes. We'll see through. Fix it in the next week.
Fine.
I have submitted this report.
Item 39.
Delay of 3 days, my lord. And I had taken the notice through special messenger, my lord. That has been sought on the
Statutory provisions under 8. Next week.
You file it. Take a short notes and give it. Yes. What is the matter?
39.
my lord, delay of 3 days, my lord. And I have taken the notice 3 days, my lord, delay.
Is the delay? No.
3 days, my lord.
3 days.
Our notice.
Already, I have taken notice through special messenger, my lord.
Requires you find requires for issuance of notice to opposite party number 2, respondent 2. Municipal Corporation.
Yes.
3
weeks.
Item 40.
296. The respondent number 1 state.
It's a remand matter from Honorable Supreme Court. But we remanded that. There are two cases, ma'am. One case here, one case, Mr. Totlang is for.
Oh, this was never listed after this, but 15/3/2022.
After this, it was not listed. Now it is first time it is listed.
What to do when all of you, because it's a hearing matter?
Hearing matter, we don't have the brief also. My lordship may call this matter any time. My lordship.
You people suggest any date?
Brief matter immediately. August 5th.
If all agrees, I don't. You all agree?
My lordship collected 12th of that was the other expense.
What?
12th of August.
No, it is up to you. I just said, if all of you agree, then
yes.
Well,
Objection,
on the consent of the appearing counsels.
41.
Last yesterday, apologies, I have filed rejoinder by yesterday. I could not file it. I am filing today. Just now they have served. Last date was given.
Come in the next week, then at least he has a right to peruse. Yes, let the rejoinder filed today be taken on record. Semicolon, the copy whereof has been handed over to Mr. Das in open court. So, to enable Mr. Das to go through the PC. Let this matter be listed. Next week. Yes, for the
Item 42.
Yes, sir. Get the post. Your lordship will say, annexure 1, page 50. A quarry lease was executed in my favor. I was the successful bidder. The quarry lease below is at page 50. This was, I was the successful bidder and I got the quarry lease. After that, I have also received the letter from the State Environment Impact Assessment Authority, wherein the earlier license that was in the name of Tehsildar has been transferred to me so that I can operate that quarry, the sand quarry. Thereafter, below, I have also got the consent to establish, then from the Pollution Control Board, and also the consent to operate. I have all these. Because while this is going on, in the meanwhile, annexure 5 is what I received. Below is that page 51.
Is what it says.
Well, may I just read it? This is
that writ petition number is given.
Yes, 23rd of December, 23rd of February 2024. Subject is writ petition such and such in the matter of an application Prashant Kumar Das versus State of Orissa before the Honorable High Court. In inviting a reference to the subject cited above, I am to request you to please go through the enclosed sheet, the date of hearing and judgment dated 6th of February 24 of the Honorable Acting Chief Justice and Honorable Mr. Justice Murari Sri Raman of Orissa High Court, Cuttack, dated such and such, wherein at page number 22, in para 20, it is mentioned that now coming to the question of protection of environment and checking of the movement of vehicles during the daytime, Mr. So-and-so Advocate General very fairly stated that there should be restriction of movement of vehicles carrying sands from 7 a.m. in the morning till 9 p.m. in the night. Page 23, para 23. State giving priority to the sand mining by manually, and as per your up to EC, you can manually continue sand mining. Now, Millards, therefore, Millards, I'll just share with your lordships this judgment what it actually is. There is no such direction in the judgment where it is prevented to carry the sand from 7 a.m. to 9 p.m. There's no such direction. it was only a submission made by the learned advocate general. What is actually the finding of this honorable court is actually para 22. It was para 20, your lordship, sir. Now coming to the question of protection of environment and checking of the movement of vehicles during the daytime, Mr. Switzerland, the Advocate General, very fairly stated that there should be restriction of movement of vehicles carrying sand from 7 a.m. in the morning till 9 p.m. in the night, 9 p.m. in the night.
No, paragraph 22, there is the court has
yes,
directed that the state authority should take necessary steps with regard to vehicular movement from 7 a.m. to 9 p.m.
Where is that
Yes.
guidance? Where is that guidance?
Where is
21, 22. Why do you delivering this document? During the state has brought forward the
No,
guidelines.
this is what order is there. It's not the submission only. It is a clear-cut order which is there in
Yes,
paragraph
that
22.
order will, what it says, that order says, further the state authority should take necessary steps with regard to vehicular movements from 7 a.m. in the morning.
No, that means there must be a restrictions which should be imposed by the state for vehicular movement between 7 a.m. to 9 p.m.
Yes, there is no such necessary steps taken by the state.
No, the steps means they will intercept that.
Yes. Now, Millard, what happens? Yeah, this is where my issue arises. I am a sandbed quarry leaseholder. I am a successful bidder. 7 a.m. to 9 p.m. I cannot do so. I cannot carry out the mining activity. Now, Millard will kindly see the
Mining activities has not been
the transport.
transportation is transportation within the city.
Because I was found, there was complaints that the heavy vehicles,
rightly
they fly during daytime. Accidents do occur.
Yes.
And
Rightly
children who go to school and coming back to school, they also face trouble. That is the.
Yes. So therefore, your lordship will see what is the
There was a
annual price.
guidelines that day we have seen, you have furnished. I think.
I was not, sorry, I'm extremely
No, that guidelines, that resolution they have passed.
Let's say, the government come up with a resolution,
Huh.
and more particular in this case, Mr. Puri was meant to me, Lordship, in this case, to assist you on that, what is the role of the Gram Panchayat, because the notification by the Gram Panchayat. And Lordship can see route.
That is my second. What I'm submitting, where is my agony arises. Therefore, the Gram Panchayat Millers now says, no, you cannot transport during the night because we are getting disturbed. So they say, you cannot make the transportation.
Catch 22 situation.
Catch 22. I am stuck between the devil and the deep sea Millers. I don't know where to go. 4 p.m. to 4 a.m. I am stopped.
What to do?
Lordship, in fact,
So
Lordship, now the
technically,
government,
What to do?
they can answer Lordship, state government to come up with.
Yes, who is the government? What is this? If you stop, then how they can issue an order that they cannot operate in the night? They have to. It's a 24 hours. You have to give some hours to them.
It is only because the direction issued by the Mughal court, it is the another 5
No, I understand. That is, so far as the entry in the city is concerned, between 7 to 9. After 9, till 7 a.m. in the morning,
This
what?
village area.
They have to. What take instructions? It can't be done. Is this a case?
That's
That the
the
Gram
case.
Panchayat has said that you can't operate?
Yes, page 53.
Now, the state has come up with a new guideline, Lordship, for the- in respect to this vehicular movements, Lordship. Because.
So, everywhere in a city
Lordship.
or a very busy town, the heavy vehicles are not permitted during a particular daytime.
In the present context, that was the issue.
So that was in every city of the country. That is the restriction that is imposed. But in the night also, if somebody says I am disturbed, then where will be the activities? Everything has to be put at halt. That will, I would say, impede the progress of the state.
But the recent lordship, one of lordship state has come up with a guideline. It has come out in newspapers, lordship, they have come up with a guideline in making participation of the Gram Panchayat, because under this, lordship can see 4/6 of the rules, lordship. And
From 4 a.m. to 4 p.m.
yes.
So it is only they are given a 3 hours time between a 4 to 7.
In fact, I'm minded of an incident that or an instance where in the Bhubaneswar airport, what they did, they said you have to enter the airport and exit the circuit, you have to complete in 5 minutes. What happened ultimately? People were it became a racing circuit. They would race in that circuit because they were given just 5 minutes, or else they will be charged for the for the pick and drop. Here, Millers, if something the time is curtailed to a 3 hours bracket, how can I possibly transport anything? And these are trucks. They are not meant to go over a particular speed limit of 30 or 40, whatever.
And then the important is that whole night you cannot.
Yes, that's the first line, Millers. It says, but not allowed to digging, transporting of sand from Lungay sandbed during night. The first lines.
And let's see the last important.
Important, that is what I'm saying, even in the night. So when?
Well, they have written. It's not allowed because of narrow path.
Rights like this, having no light facility. How? Not having light facility. They're in so dark.
Nice.
Who is to facilitate lights in Gram Panchayat area?
On these points, that second prayer is for extension of the lease period.
Obviously, if a person, may I use the very strong words, is changed from all the angles. What he will do? He will do a query operation for what? To upload it on the truck or whatever. The intention is to transport. He will simply make a query. When it's tagged there, he will not be permitted to take it out. What is the purpose of the query permit? If they are not allowed to sell, they are not allowed to take it out, then what remains? It remains there. Is there any way that the aerial transport is there, that can be transported? There is that aerial transportation.
But in fact, difficulties lordship in the Gram Panchayat areas, they are not allowed to use mechanized manner lordship. They are extracting sands by using mechanized manner, and they are transporting by heavy vehicles like a highways lordship.
Has to be.
No, lordship, now they have restricted lordship, but they have come up with a new guideline. But pursuant to direction of this HON'BLE court, they have come up with a perhaps we have come up with the newspapers.
Pursuant to direction, but they have brought out because of that during pendency of that regulation, right? We were about to dispose of them.
Lordship.
And they brought out one.
No. Recent lordship. Last week, perhaps they have come up. That guidelines was in concerns with the sustaining sand.
Guidelines.
I'm not feeling that.
If the state has taken out, then the panchayat, do they have the ability to pass such a law? First thing is, let me understand that there is a panchayat that.
Yes, Gram Panchayat.
There is a Gram Panchayat.
Exactly.
Do they have powers under the Gram Panchayat Act to pass such a kind of a law? Can they? So far as the transportations are concerned, either within or around the ground, the village area, only the street.
What are the motor vehicles are?
But Lordship, under the sustainable sand mining management guidelines, for vehicular movement, Gram Panchayat is a necessary party. In consultation with the district administration, they can come with a vehicular policy, how the transport will be made. They can take a decision by the district administration, but Gram Panchayat will be party to that.
What for?
Lordship, for smooth vehicular movement, Lordship, because Lordship.
Move for.
Lordship,
Can they create a obstacle into?
No, the Gram Panchayat don't have power.
Question is this.
Let's we can have a glance rule 4 for a moment, 4-6 Lordship for a moment. For this reasons, Gram Panchayat has a role in this mining activities, Lordship. Rule 4-6
of
OMMC rules 2016.
Lordship.
OMMC rules 2016.
Rule 4-6 Lordship.
Rule 6
Lordship.
The recommendation, Gram Panchayat's recommendation is taken.
They have a role in these mining activities. Gram Panchayat has a role, Lordship. No prospecting license from mining lease or mining lease or quarry lease shall be granted in scheduled areas. It is scheduled area.
At the time of granting the lease, the consent or the recommendation of the Gram Panchayat.
Yes.
But for regulating the movement of the class.
For vehicular movement.
I just wanted to. That's the power of the Gram Panchayat.
Yes.
To pass such kind of an orders.
No, Lordship. Gram Panchayat no independent power.
No.
That is their Lordship.
How can they do it?
Lordship. It has to be in Lordship by the district administration, by these mining authorities, and where the Gram Panchayat will be a party. They will consult with Gram Panchayat what should be the time and what is the route and how can be transport. That is the
no. This is what is the just to streamline the thing so that in future there cannot be any dispute. That is one thing. But once the power is not listed, the Gram Panchayat is the creation of an act. Correct. By virtue of a constitutional provision where the Panchayati Raj administration was also accepted in by within the constitution. From there they derive the power. So if they derive the power from the statute, then they cannot travel beyond statute. That's not such an order.
This notification absolutely, this order perhaps lacks competency, Lordship. He can come. Gram Panchayat. Perhaps.
Have you made them a party?
Yes. Party number 3. Respond number 3.
Are they appearing?
Not representing.
Who's representing the Gram Panchayat here?
Notice to go, Lordship, you can do that. This is remote area.
Yes. Is there any other separate?
No, independent body election notice to go. No, there is no
panel or something?
No, Lordship, nothing. More than 6,000 Gram Panchayats. Every Panchayat is independent power, so notice to go, Lordship. There is no panel.
Give a notice and then yes. Notice of the Gram Panchayat is the opposite party. Please. Notice. Which are after 2 weeks. We are giving a short time. You immediately effect the notice by tomorrow.
43.
That's what is happening with us.
2019, you are
no, I am only submitting. My lease period has also ended in the meanwhile during pendency of this case. So, Bilals, now there is a possibility of floating another tender for the same place.
Interpretation or apprehension guarantee pass.
Very good. As a matter.
Item 43.
No.
the blocking of portal where the guideline of the state provides the minimum blocking period of 180 days. And if you want to file a unblocking application of his portal to participate tender, then I applied in terms of by depositing the required fees. And the tender authority required to mandatory shall recommend the authority for unblocking below. My application is filed 10th April 2025, and the minimum period of 180 days expired. They have not taken, my lord. I have filed this IA flag D, my lord.
My lord, in this matter, we file counter affidavit, one transfer given.
Why? See,
The last occasion.
you can block up to 180 days. 180 days has
Already expired.
expired. Then what more? You have to open. Yes, sir.
The guideline is page C/2, counter page, internal page 26, flag B.
Flag?
This is flag B, your lordship, counter filed by the state, your lordship.
C. That's C.
Flag C. Annex C/2. Annex C/2, page 26.
26.
Flag C. Page C/2. Your lordship. 24. The minimum period of blocking of hotel registration shall in no case be less than.
It means they have to block it for 180 days. But it does not mean that they cannot block it for.
They have next line, your lordship. After blocking of portal registration, the contractor whose portal registration has been blocked may file application to the concerned officer inviting tender showing sufficient ground for unblocking of his portal registration along with a treasury challenge of rupees 10,000 non-refundable under the head accounts of public works as processing fees. The office inviting tender shall forward the application filed by the contractor to the chief manager taking state procurement cell. And in Milord, I flagged the application already filed. It has not been forwarded. No decision is taken. So there is no upper limit also fixed. Milord. The committee may decide. That's my answer.
What are they doing?
Book of this matter on Monday minute, I will take it.
Monday?
Yes, sir.
Item 44.
I'm a work contractor. I have participated in tender.
Item 44 is paid for 3 weeks time for filing counter.
Let me see. I have an objection to that. Why? I have filed my I participated in tender. During after the tender, I have participated in tender. The notice comes that you have been blacklisted and you have suppressed. I state them that I don't know about anyone who was being a joint venture partner, dropped the bid, and I don't know the so and so person, and he had participated without my permission. The said fact is found by Guwahati High Court, and Guwahati High Court says that yes, he was not aware of it. Now I again filed an application. They did not remove my name from blacklisting list of contractors blacklisted. I again make an application before Guwahati High Court. Then again Guwahati High Court allows it and removes my name from the blacklisting portal. In the meanwhile, this tender where I participated in the Bhubaneswar zone, they have forfeited my aim. Now I paid for UMBF that you release my aim because I was not. It is not my mistake. They do not release it. I come before this honorable court. This honorable court grants them time that you take a decision because it's pending before the railway board. Now railway board after this order has taken decision. It is at the impute notice. Annex 14.
Yes.
It says that please wait till railway board takes a decision. Because I am an MSME, I cannot do. Now, Milords, may see the orders that have been passed. The first order, Milords, is 4/2025. There is a direction that if you do not file a response, you either file a response or come with the money. They do not do. Now, Milords, this honorable Milords, see order dated 15/4/2025. Look, 5,000 cost was imposed on the DSGI office by your lordship. You pay because of your delay. There has been the reply was not filed. This has not been complied. The next order may be seen, Milords.
Yes.
Para 2 Millards, the Learned DSJ office says, Mr. Samantrai, Learned Council, Government Council, Learned Central Government Council submits that in spite of favorable requests, the opposite parties are not responding to the same. The court expressing its displeasure, the indifferent attitude of the opposite party dated for payment of cost of rupees 5,000 by order dated 15/4/2025, which has also not been complied with yet. In view of this, the court feels the notice should be issued to the opposite party seeking their response. Hence, notice be issued to the opposite party by speed post. I complied. Notice is delivered. Now, C is the tender inviting authority. The decision is pending with opposite party number 1. C is for opposite party number 3. Now, opposite party number is not neither taking decision, sitting over my money, and after even that issue being adjudicated by the Guwahati High Court, still is keeping over, sitting over it. The on court of
He is representing whom?
Opposite party number 3.
Who is he?
See, he is the tender inviting authority, rights. Tender inviting authority. And they are saying that money can be only released after the railway board takes a decision. Now, maybe not railway board, my tendering inviting, you having invited tender, my money has to be released by you. Now, you are not releasing the same tender inviting authority to release. And I am kept pending for so many years, Lordship,
I'm apologetic for that. I'm appearing for OP number 1. We have already intimated. For OP number 1 is silent over the matter. That's why your Lordship, this Honorable Court has been pleased to issue notice. Now, your Lordship, I'm apologetic to say that despite our several communications, no information has been received as of yet. Despite the notice of this Honorable Court, still they have not appeared.
We are directing you to release the
Your Lordship, I'll be obliged by the order that is passed by this Honorable Court. Because OP number 3 is dependent by
time
the
filing counter. Short time only. Only short
Where
time.
you were, madam, this matter is pending since the month of February. Where you were?
Only 1 week
No.
maybe allowed.
No, we will impose a cost of rupees 25,000 on this. Will not your time, but for 25,000 rupees cost. Okay.
As your Lordship.
Yes, 25,000 rupees
No.
cost. Yes.
Without cost.
they are not filing reply. They are not appearing even.
Faraway
Even
comments.
on DSJ also said that they are not responding to me.
No, pursuant to the notice I appeared.
DSJ
And,
is saying that the notice was earlier served upon you. There was a second time the notice was given to you.
There is also been communication from the office of DSJ.
To the opposite part number 3 minutes.
This was communicated to you.
Short time maybe allowed.
I find that in the month of, that is on 25th of February, that the parties were permitted to file their counter.
Yes.
The part number 3.
You did not.
You were served with notice on 28/4/2025. So that is the process.
2.5 months minutes they have not done.
Yes, as they are not responded, I requested the court to issue notice.
Yes. Yes, Mr. PSG.
Because repeated letter has been sent and they are not responding, I requested.
It's better to dispose of the matter.
Yes.
Yes, you are the Sumcon Infra Ventures LLP.
Yes, sir.
And the banning was done to Mrs. Sumcon Avijantrik JV.
Yes.
Is a joint venture.
Yes, it was joint venture. The judge Avijantrik had taken my credentials and without my permission participated in the bill. That was also held by the Honorable Guwahati High Court. And that Avijantrik also gave an affidavit that yes, I have done this.
Where is the letter of 20th of January and 1st August? You wanted actually now the refund.
Yes. Only my EMD to be refunded.
And the blacklisting has already been removed.
My name has also been removed.
No, now this is that letter, 20th of January and 1st of August,
Yes,
where they banned you.
yes. It is at Millard's page.
First, the second relief which you are claiming, I'm just looking at it.
Yes.
What is this letter dated 20th of January 2023 and 1st August 2024?
Where they forfeit my END.
Oh, forfeiture of.
Yes. Along with blacklisting. Blacklisting has been decided by one court.
Along with the blacklisting.
Yes.
So partly it has been allowed. Partly.
It has to come before this honorable court because the respondent is here.
And now they are not refunding. You were not permitted to be to participate.
Participation I am now being permitted because after
in that
yes.
tender.
Yes. I was not allowed.
Not allowed. Take. Rakho.
The next item, there was only formally the amendment may be allowed. There's an amendment application at flag.
Which one?
45. There was a, by the order dated, order number 5, your lordships had directed me to impede the DFO custom. So that amendment may be filed, accordingly filed the amendment.
Why amendment? It's an addition of party under Order 1, Rule 10(2).
Fine.
Why amendment under Order 6, Rule 17?
The court has said that impede.
The implead means Order 1, Rule 10(2).
Sorry. Order.
Why amendment?
Completion.
This, though the application is captioned as an application for amendment of the writ petition, but in fact, the petitioner intended to implead whom?
This honorable court directing us deposit of 50% of the demand, that specific direction that forthwith they will issue a transit permit. Now we have deposited the amount, we have complied with the order, but still then they are not issuing the transit permit despite the direction that forthwith they will issue.
Who is appearing?
State will be appearing. I'm appearing.
So why, if that being the position, why you are not issuing the transit?
By now we have already lost 50
If the court is, the court has passed an order.
Then submitted it as true. I can't have any objections. Can it come on 14th or even?
Come on Monday, in the meantime, take instruction.
That's
We'll
right.
take up this matter, because for this purpose that you
That's right.
issue.
So great punch.
Yes.